The other one you gotta. So I guess we need to break part of it. Who didn't even do that? You know, when I was a kid, you could go to the bookstore and buy the book. It didn't work out. So that was a fun discussion.
Hey, Kathy, are you there? Is Kathy there, Miss Jones?
Kathy.
Oh. This was quiet.
All counts were concurred.
All rise. Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. Honorable Judge Charles E. Jr. now presides. Court is now ordered.
Please be seated. Give me 1 minute. Okay. This. Just outlining it for me. All right. Okay, this is 22 SC 1811793. Sharon Varner. Where's Miss Varner? And then Mr. Davis. And then we have Mr. Obviously Mr. Watkins with the state.
That's correct, Your Honor.
So you have a plea to present, right, Mr. Watkins, a negotiated plea?
That's correct.
All right, go ahead.
Your Honor, in this case of the state of Georgia versus around Nicole Varner, case number 22 SC 181793. This is a change of plea. Where Ms. Varner is entering guilty pleas, a negotiated plea agreement to counts 2, 3, 5, and 7. And if we could proceed with the waiver of rights and.
Go ahead, Mr. Watkins.
Or if you could raise your right hand, please.
Judge, could you get Mr. Watkins to speak into a microphone, please?
Oh, yes, that's right. You're welcome to just sit at the witness box there, Mr. Watkins.
You can raise your right hand, please. Could you state your true, correct, and legal name?
Sharon Nicole Varner.
And if you could speak in the microphone as well, because the court reporter happens to be by Zoom, so.
And do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, please. Ms. Varner, at this time, are you taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
How old are you?
34.
And how far did you go in school?
Some college.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are presently charged in this bill of indictment with, under count 2, violation of oath for reckless conduct, count 3, reckless conduct, count 4, aggravated battery, count 5, aggravated assault, and count 7, violation of oath?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you reviewed the waiver of rights form with your attorney, a copy of which I'm holding up before you?
Yes, sir.
And have you had enough time to speak with your lawyer, Ken Davis, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with Mr. Davis?
No, sir.
And are you satisfied with the services he has provided to you?
Yes.
Do you waive a formal reading of this indictment?
Yes.
Do you waive any and all defects in this indictment, including any defects in terms of time or respect to your name?
Yes.
And you have previously been arrested on these charges, correct?
Yes.
Has your attorney advised you of the minimum and maximum sentences for each charge
Yes.
each charge that you are pleading guilty to? Is that a yes?
Yes.
Okay. And is your understanding that the maximum amount of time that you can receive on violation of oath of office would be up to 5 years confinement? For reckless conduct, it could be up to 12 months confinement. For aggravated assault, up to 20 years confinement, and violation of oath, up to 5 years confinement.
Yes, sir.
Do you understand that you are today entering into a negotiated plea, which means that the state will recommend to the court the following: that for a guilty plea of violation of oath of office, a 5 years probated sentence; that for reckless conduct, 12 months probation; that for aggravated assault, 5 years probation; and violation of oath of office, 5 years probation, to run concurrently with each other, and that the state will dismiss or null pros count 4, aggravated battery.
Yes, sir.
Do you understand that this plea may be used to enhance to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a plea of guilty today?
Yes, sir.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to the revocation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in the deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
And as an example of that, a guilty plea may affect your right to vote, the right to hold public office, the right to serve on the jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
And if you plan on asking the court to impose a first offender sentence, that if you have ever pled guilty or no nolo contendere or no contest to or ever been convicted of a felony of in the state of Georgia, any other jurisdiction, that may affect your ability to plead to a first offender.
Yes.
Have you ever been sentenced for a crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer, Mr. Davis, explained the First Offender Act to you?
Yes, sir.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each count in the indictment?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to a court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
As it pertains to counts 2, counts 3, count 4, and count 7 of the indictment, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea or conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And Your Honor, if I may, at this time, give a factual basis for the plea.
Go ahead, Mr. Watkins.
Judge, on December 28th, 2018 in Fulton County, more specifically beginning in the city of East Point, an undercover officer with East Point was observing a vehicle believed to be stolen. He saw this vehicle at the racetrack on Camp Creek Parkway. That vehicle was being driven by Mr. Devin Nolly. That undercover officer followed the Nissan to a shopping center across the street when the Nissan stopped in front of a Publix grocery store. The undercover officer got behind the Nissan, and Officer Varner and another officer, ETN, who's also named in the indictment, approached to partially block the Nissan from the front and side using their marked East Point patrol vehicles. That officers Etienne and Varner emerged from their vehicles with weapons drawn, issuing orders to detain Nolly, who remained in the vehicle at that time. That Mr. Nolly shifted the Nissan in reverse and then drove the Nissan to get around and through the East Point vehicles, but also towards officers Varner and Etienne. That both officers opened fire, discharging several rounds toward the Nissan, even as it passed them and drove by. However, the officers continued firing of their weapons outside of their effective and well beyond their effective range. That a round continued downrange into a drugstore window where the glass shattered, causing cuts to the face of a Miss Shamika Webb. Those acts gave rise to reckless conduct and violation of oath. That Etienne and Varner got back into their vehicles and continued their pursuit of Nolly in the Nissan, eventually onto I-285, where South Fulton Police Department then joined in the pursuit. That an officer with the South Fulton Police Department performed a pit maneuver, causing the Nissan to go out of control, crash into the median and wreck, where Mr. Nolly then climbed through the window because the door was jammed. Upon him using both of his hands to climb through the window, Mr. Nolly jumped from the vehicle, landed on the ground, putting both of his hands on the ground. And from there, Officer Varner emerged from her vehicle and then began firing at Mr. Nolly as he fled with his back facing Officer Varner. Officer Varner fired 2 shots as Mr. Nolly jumped over a railing on 285, where another officer fired at him, having been spurred on. Under our impression was that he believed he was firing because in response to the shots initiated by Officer Varner. After Officer Varner shot 2 times, then Officer Etienne continued firing Nolly as he ran along the grassy area along 285, eventually striking Mr. Nolly in the back, causing his paralysis. As a result of these, the conduct of Officer Varner, and that Mr. Nolly did not reasonably appear to possess a weapon when he emerged through the window of the Nissan, landed on his hands, and then as he fled from her, she fired at his back, and that Mr. Nolly being eventually struck, that gave rise to the charge of aggravated battery and aggravated assault. But because she only fired 2 times, and based on expert testimony, the doctors will testify that it was not the shots from Officer Varner, but from Officer Etienne that caused the aggravated battery. The state is null processing that count. But because there did not appear to be at that time any evidence supporting firing at Mr. Nolly as he fled with his back facing Officer Varner, it did give rise to the charge of aggravated assault for excessive force and reckless conduct. It is the state's position that that the officers under 17420B could potentially have a defense to these charges. And as a result of that, and after consultation with Mr. Nolly, who does not object to this disposition, the state offered the negotiated plea to the counts before your honor, which would be count 2, violation of oath, count 3, reckless conduct, count 4, aggravated assault, and count 7, violation of oath. That because Officer Varner fired twice, however, her conduct did cause the initiation of several shots at Mr. Nolly, but nonetheless did not cause his paralysis. The state is recommending that this court accept the guilty plea and is also recommending a sentence of 5 years probation on count 1, 12 months probation on count 3, that being the reckless conduct, 5 years probation on aggravated assault, and 5 years probation on violation of oath, all counts to run concurrent to one another. The state recognizes that this case, the defendants may have a defense under 17420B, and that prior precedent allows an officer to believe that a vehicle can be used as a weapon. That's why there were no aggravated assault charges that pertains to the incident that happened at the shopping center in front of the Publix. However, the officers continued firing at this vehicle as it fled out of the effective range of their weapons, causing a round to go through a drugstore and resulting in a injury to a patron there. And also the lapse of time between this incident date and the initiation of criminal proceedings. And the fact that the state cannot prove aggravated battery against Officer Varner. Therefore, we're dropping that or asking the court to accept dismissal of that charge. And on that basis, Your Honor, we are recommending this particular disposition of this case.
Okay, Mr. Watkins, so the aggravated batteries count 4 and aggravated assaults count 5?
Correct.
Okay, and the count 4, the aggravated battery, you're no prosecute.
That is correct.
Refresh my memory, hypothetically on a first offender, if she were to violate the terms of her probation, the aggravated battery's gone, right? That can't come back.
That is correct.
Okay. All right, go ahead, Mr. Davis.
Your Honor, the defense has nothing to add at this point.
Okay. All right. Couple question. I mean, just a couple things I want to go over with Ms. Varner. You understand your attorney's gone over first offender with you?
Yes, sir.
And so I know Mr. Watkins went over the maximums again, but I just want to make sure you're aware of the fact that if you do violate the terms of your probation, you can come back in front of me and be facing a potentially in confinement 5 years on count 2, 12 months on count 3, 5 years on count 5, and 5 years on count 7. You understand that, correct?
Yes, sir.
It's a two-edged sword, obviously. You would get credit for any time you'd served on probation up to that point. But we'll think positively and assume that you do comply with the terms of the probation. And if you do so, then you will not have been convicted of a crime in this case. So that's the advantages. That's the positive. Do you still want to go forward with the first offender?
Yes, sir.
Okay.
And Your Honor, for me.
Mr. Watkins, please.
The additional terms of the probation called for Ms. Varner to surrender any arrest or law enforcement licenses that she has during the term of the sentencing order, to pay a fine of $1,500 plus surcharges, complete 60 hours of communities, and complete 60 hours of community service.
How many hours is community service?
60.
All right. I guess what should the time certain date be on a community service?
For completion, Your Honor?
Yes.
We had not discussed that.
I like to have a backstop because I've had cases where it doesn't get completed and first offender cases, and then it expires. And so what's a reasonable amount of time to complete the 60? It doesn't, I mean, whatever's you're comfortable with. I'm not looking to put pressure on you, but there has to be a time certain before the 5 years.
Your Honor, within 2 years of the commencement.
Okay.
And Your Honor, I would also like to add for the record, the surrender of her post certification. She's no longer post certified at this point.
Okay. Okay, Ms. Varner, do you understand the nature of the charges against you?
Yes, sir.
You have just heard from Assistant District Attorney Watkins explain all the rights you give up bearing this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand that the court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Davis, are you satisfied that your client is competent and understand the plea is voluntary and that there is sufficient factual basis for entering the plea?
Yes, Your Honor.
Okay. All right, the court finds that you, Ms. Varner, understand the nature of the crimes and the consequences of this plea. There is a factual basis for the plea. An defendant has knowingly, intelligently, and voluntarily entered this plea. Defendant has requested a sentence under the First Defender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event that the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended sentence. And so on count 2, violation of the oath, that will be 5 years probation. Count 3, the reckless conduct will be 12 months probation. Count 4, the aggravated battery will be no pros. Count 5, the aggravated assault will be 5 years probation. And count 7, the violation of oath will be 5 years probation, all of which will be served concurrently. And you have special conditions. You're to surrender any law enforcement licenses. I know Mr. Davis said for the record that she's no longer post-certified, but that is a special condition. You are to pay a $1,500 fine and perform 60 hours of community service work within 2 years. Is there anything else?
No, Your Honor.
No, Your Honor.
Okay, you're excused.
Thank you, Your Honor.
Your Honor, probation report and instructions.
Oh, yes.
If Ms. Varner can have a seat, I'll be up in a second to sign her up.
Okay.
Thanks.
All right, Mr. Watt. I guess Mr. Samuel filed a conflict.
He did. My understanding, he remains in trial. I don't know what state that is, but I think he's out of the area.
I believe he is on a second trial.
Okay. All right. Well, we'll have to reschedule that then. You're excused, Mr. Watkins.
Thank you, Your Honor. Appreciate it.
Is this the first time you've been in here with me or?
No, I've been.
I know on Zoom, we've been, well, I'm sorry. I guess I insulted you there, but
It's a great appearance on this stage. I think it was.
that's right. That's right. That's right. They've been in here. All right. Well, it's
Thank you.
nice seeing you again. So you guys are just, okay. All right. Cause I did lean over. I'm like, well, what are they doing here? And I guess just can't get enough, huh?
Both of us cannot read apparently. We just assume 9:30, you know, we're early, see? that's
Yeah,
what
yeah.
it
Now I know. I appreciate that respect that you give the court. All right, here you go.
Thank you.
To be honest with you, I thought I'd missed something, like one of y'all had a motion that I wasn't prepared for, so. We'll go back where civil is not so civil. It's really turn this off here. It's really the only time I ever lose my temper is in civil. I try to never, but.
Ms. Jones,
Yeah,
so Desmond Harris,
yeah, he's not confident.
well, I got a.
Yeah, I saw that. He's in,
Oh, I said it to you.
yeah, he's
Okay, I'm
getting
sorry.
restored as we speak.
I'm sorry. I forgot I sent it to you.
Hopefully he's getting restored.
And Mr. Clark, I took off Mr. Wilson and Mr. Mason.
Mason.
Can I go back there real quick? I just need to see Miss Frost.
Yeah. Yeah, I did. Yeah,
I just got it.
Yep. Yeah. Should be 11. Yeah.
Yeah, that might be. Yeah, first.
That's there.
they still live here in Atlanta?
The girls. Dates.
Hey, Ms. Jones and Mr. Clark. I think y'all's mic is still on. I keep hearing little things that like I can kind of hear you talking. Just FYI.
I don't think it's ours. It must be the podium that's picking us up.
Oh, I see. I was just making sure y'all weren't whispering top secret confidential information.
Right? Yeah, we're just early. All right. Okay, well, great.
Oh, probation, sorry. I don't have any. But I don't have any works out. I think they're having. Here.
No, it's all good. Oh, good.
Yes.
Thank you. Denisha Austin. College number 6 here. Number 6 here. Probation officer here. But whatever you're happy, you're comfortable with. Okay. I like
Oh, and it's your.
Yes, to the back. Oh. Was that it? For today? No. Oh, okay, well. No, not, no. Oh, okay. Okay, okay. Ready? You're right now. How are they? All the information on, social. Face, the address. Oh, hold on. I didn't. No. You gotta realize we're dealing with somebody. NSA, FBI, and the CIA. You know that. They're not supposed to have that. That's messed up. How they get threats? That's crazy. It's out of control. I have heard that. Yeah, I was just about to sit in my office. I was like, that ain't worried, man. That ain't. I'm like, big shit. What's up, Red Jury? What's up, Jury? I can't believe that ever. Hey. Issues of. Hey, come on. I watched it live. Hey, at the school. Yeah.
same person that was on. So is that for? She was also kind of a special person in probation compliance. Okay, so you remember. She did really well. This was that egg salt. I think she should probably remain on. Sure. Because her big issue is. I think either you're. Just to make sure she's, I mean, her big issue, she needs them. She doesn't have an issue with paying. Okay.
You might be taken down. Okay. Anybody else not coming? Yeah.
What's the?
Judge Eden, will you let Miss Robinson know that 88 Peterson is waiting to get into Zoom?
Okay.
Thank you.
you let the person in that's waiting?
Yeah.
Where's Miss Jones? She? Okay. Okay, sure. No problem. What's the, just so I know, tacking on here, what's the case number? Why? What's the defendant's last name? Wilson. Well. Let's look it up. So what happened in July? Wasn't on the calendar in July?
But when the calendar was sent out, I was.
Okay. What was your name? EKAURE. Okay. Okay. Hey, Ms. Clark, are you there?
Yes, Your Honor, I am.
I'm just giving you a heads up. We're going to add a case here at the end. It's a very old case, and the case
Okay.
number is Y03225. And Mr. Wilson is the case. Apparently, he's had a bench warrant out there for like 20 years. And he was scheduled for July 10th, and there was miscommunication over that. So we're going to talk through it, but I did want to give you a heads up. So
Your Honor, do you mind repeating that case number again, please?
sure, it's Y03225.
Okay,
Apparently,
thank
that's
you.
how they numbered him 20 years ago. So
Got it. Thank you.
you're welcome. All right, let's get moving on the rest of the calendar. So. All right, let me take announcements. We've got 20 positions. So we will begin with position 1, Courtney Brown.
Yes, Your Honor. I believe this is 88 Ernell Winfrey's case. We've been served discovery on this. If Your Honor remembers, this was on for a trial calendar final plea at the beginning of May. The state at that point re-indicted the case. This is the new indictment number. To add positions 2 and 3, which are co-defendants who are not on the original indictment. From my understanding, neither of those co-defendants have been arrested at this point in time. Mr. Brown has been in jail for over 900 days. I believe the state made some announcement, this is my recollection, that they intended to try the case together. Obviously, that's of grave concern to Mr. Brown and myself, given the fact that neither of these individuals have appeared for court. So I would be asking the case be set down on the next possible trial calendar. We have not received an offer yet in this case, are open to discussions on resolution, but have not received a plea offer. And I've discussed this with Mr. Brown. I can repeat that announcement if necessary.
Yeah, I guess we did sort of bleed into who's subbing, who is Miss Winfrey on?
Your Honor, it's 88 Terrence Miller on behalf of the state.
All right. This was really, since the defendant's out here, we'll roll with it. But let's see here. Okay, so I'm looking at my notes here. Wasn't that long ago that we were in here. All right, so this is 23 SC 187734, Courtney Jamal Brown, who's joining the courtroom with his attorney, Mr. Clark. And we have Terrence Miller on Zoom. Go ahead, Mr. Clark, with what you were saying.
As I stated, Your Honor, for Mr. Brown's benefit again, Mr. Brown has been in custody for over 900 days. This case on the previous indictment was before Your Honor in May for a final plea. At that point, Ms. Winfrey announced that she would be re-indicting the case, which she has done. This is the new indictment to add 2 co-defendants. As of right now, I cannot see that either of these co-defendants have been arrested on the charges. They do not appear to be present before the court. Ms. Winfrey announced that she intended to try these cases together. Obviously, that's grave concern for Mr. Brown, given that he's been in custody for this extended period of time. And there's no definite, I guess, time when we can say that this is going to happen, given the fact that these other parties haven't been arrested or aren't making an appearance. So we're requesting that this go down on the next available trial calendar. We've not received an offer. At this point, I do believe we've received complete discovery. As far as I'm aware, we have received that. Open to some sort of discussions or resolution, but at this point that we would just be seeking a date certain as soon as possible to get a resolution on this. Because from my perspective, if the state intends to try this going forward jointly, I don't know when that's going to be. And he's obviously been in custody approaching 3 years now. So we just need a trial date.
All right, Mr. Miller.
Yes, Your Honor. That is correct, Your Honor. The other 2 co-defendants, to my understanding, are not in custody. It's my understanding that position, I'm not sure if he's position 2 or 3, but co-defendant Al Bones is in custody in another state on other charges in which he's already pled. And so we would be seeking a production order to have him brought here to the state of Georgia to answer for the indictment. And so if we are to try all co-defendants together, we would be able to apprehend Mr. Bones. In regards to the co-defendant Anthony King, however, it's my understanding he's not in custody. I do understand defense's position in regards to his client being in custody for so long without a trial date. And so I would ask that the co-defendant's attorneys, especially for Mr. Bones, have an opportunity to view discovery, file any motions that they deem appropriate, and that this case then be placed on a trial calendar following that date.
And Your Honor, the one thing I would add, I guess, on my behalf is, or Mr. Brown's behalf, it is frustrating in the sense that in reviewing discovery, I believe these individuals had been known to the state much sooner than May of this year. So for the state to bring a separate and superseding indictment, adding them as co-defendants this late in the game, I understand the need for their attorneys to get up to speed on discovery. This really needs to be set down on a trial as soon as possible. What I'd notice, both co-defendants, and I believe listed in Odyssey with addresses in the state of Arkansas. I'm not sure if that's where Mr. Bones is serving right now, but that gives the added complication of getting the third co-defendant in the court, is that he is an out-of-state co-defendant as well.
All right, so Mr. Miller, it's one thing to understand the frustration that Mr. Brown has. I know you tossed to the attorney. So what's going on? I know you said Bone is in jail and that's probably getting resolved. What's going on with King? Okay, that's right. Let's talk about all three of them since they're all on. So this is position 2. We have Al Bone Jr. That's also 23-187734. Who's representing Mr. Bone?
I have Mr. Bones.
And what's your name?
Euphemia Cabrera de Moore.
Okay. All right.
And Mr. Miller is correct. I spoke with Mr. Bones' attorney in Arkansas. He has a federal case in which he's entered a guilty plea. He'll be sentenced mid-September. And he at that point, he'll be done then, but he'll be in federal custody. And the state was able to, I believe they sent me a link for discovery in the past 2 days.
So in September, he's going to be sentenced, and more than likely he will be in federal custody after that.
He will definitely be in federal custody. He has a mandatory 10 years to serve.
All right. So we will have to do the paperwork for that to get him over here.
Yes. And that's also going to make it a little difficult for me to speak to him until we can get him here. I have contact with his family. I can access him through his family. But while he's in the shuffle from, I guess, wherever they have him now to where they're going to officially place him, my contact with him is going to be limited until he's officially situated.
All right, let's jump to Mr. King, Anthony Dwayne King. I see Mr. Hornsby Wilson.
Yes, good morning, Your Honor. I was just recently appointed to this case exactly a month ago. And so I've had no contact with Mr. King. I did receive discovery, though, from ADA Miller a couple of days ago. And that's really my announcement on this case.
Where is Mr. King?
Honestly, I don't know. I haven't had any sort of contact with him since I was appointed to this case.
Well, Mr. Miller, what are the plans?
Your Honor, I'm looking at Odyssey. It does not appear the two outstanding defendants have any warrants. So I'm a little concerned about that. So I will reach out to my office to talk about having those warrants issued. So I know we should be able to, again, obtain Mr. Bones. In terms of Mr. King, I will talk to someone in my office to see if we can issue those warrants for his arrest.
I mean, obviously, this is frustrating because we've got a defendant that's been in jail for almost 3 years. And there haven't even been warrants issued on his 2 co-defendants. Mr. Miller?
Understandably so, Your Honor. If the other 2 cases are placed in judicial hold, then the state would be ready should the matter regarding Mr. Brown be moved to a trial calendar. Given that he's been in custody for so long and those 2 other co-defendants are outstanding, we definitely don't want to impede the progress of this case or the administration of justice in regards to the charges against Mr. Brown.
I guess I'm not following you when you said the judicial hold. What did you mean by that?
Well, if the other 2 co-defendants matters are placed in judicial hold, given that they have not been arrested, then the state would move forward on the new indictment against Mr. Brown. And we would then also work on having those warrants issued for the outstanding co-defendants. So we understand that if they are not in custody, if they've never been arrested on these charges, we don't expect the court to allow us to just wait as Mr. Brown languishes in custody while we apprehend the other 2 co-defendants.
Okay. When is Bone sentencing?
They don't have the exact date. The attorney, he was in the car when I spoke with him. So he said he'll let me know, but he said it's the middle of September and he'll get me the exact date when he can get back to his office.
Okay, I'm going to sit down with Miss Robinson after this and come up with a trial date for Mr. Brown that will be after September, but not too long after. And if the co-defendants are ready, they're ready. If not, we'll go forward with Mr. Brown. Okay.
Yes, Your Honor.
Anything else?
Nothing further from the state, Your Honor.
All right.
No, Your Honor.
Just a quick question, I guess. Would that mean, I'm assuming that the co-defendants are not going to be ready in September. I mean, we have to.
Well, it won't be the trial date won't be September. It'll be after that. I just need to speak with Miss Robinson about that. But
in the event that they aren't ready, or does that mean that the co-defendants will be severed, or?
Well, they're ready. We can try all 3 together.
Okay, I guess I understand.
I mean, for now, I mean, you of course retain the right to issue motions for severance, and I'm not making a blanket.
Gotcha. Okay.
Here, but if they're in custody or come forward before then, I mean, my intention would be to go forward with all 3 as defendants.
Okay.
Okay. Anything else?
No.
All right. You're excused, Mr. Brown.
And thank you, Your Honor. That concludes my business before this court. May I be excused as well?
Yes, you're excused, Mr. Miller.
Thank you, Your
And
Honor.
Mine as well, Your Honor.
you are as well.
And mine also.
You are?
I am. This is the only
Have
case-
one?
Yep.
And schedule enough then.
Well, no, I think we've had enough from earlier this week.
All right. You're excused.
Thank you, Your Honor.
Thank you, Your Honor.
Bye-bye. All right, so wait, let me just go ahead and ask, is Mr. Rosenblum on it this minute? I know he's kind of in and out. He's got some conflicts.
Attorney Mike Barber for Mr. Hammond, Your Honor. Mr. Rosenblum was standing in for me while I was trudging back from Douglas County.
So okay, because Rosenblum's, not that this is the end all be all by any means, but Rosenblum is listed as the attorney in our database.
We work together. Your Honor.
Okay, thanks. All right, so obviously this is for Isaac Hammond. I'm really just taking announcements at this point.
Sure, sorry, I almost cut you off. Apologize.
No, that's all right.
Mr. Hammond was reset last time so he could get his psych eval. We do have a psych eval, but he needs to get another one because this was for inpatient treatment. His next appointment is August 24th at 8 a.m. That was the quickest he could get the two done. He did get another one done. I don't have a copy of that handy for me to put on a screen or anything. But he immediately got another appointment when he found out that they were not doing what he needed at the previous place he went, which was for, who was this with? San Antonio Behavioral Health Care.
All right, Ms. Clark, do you have this case?
Yes, Your Honor, this is my case.
So I assume you don't have an issue with continuing it for the next psych eval?
No, Your Honor, the state does not.
Okay. All right. How much time? When do you want to put this back on?
Well, if he's getting the next one on August 24th, I mean, anytime after that, Your Honor, because I would assume that would be one I can get a report from and get over to Ms. Clark.
Your Honor, if I could suggest,
Wait a minute, two people talk. What, Miss?
Yeah.
Really? My litigation manager's saying you're being awfully optimistic, Mr. Barber.
Well then, I guess I'm hoping.
Your Honor, if I may suggest, in lieu of the fact that another evaluation is going to be done, I would probably say a reset to another case management date of 60 days.
Well, that's what we were just discussing.
Yeah.
So
Mhm.
let's do that. Reset for 60 days to another case management date.
Yes, Your Honor. Ms.
All
Clark,
right.
can you text me your, in the chat, your email address so I can email that to you when it comes in?
Okay.
I would appreciate it.
All right.
That concludes my business, Your Honor. May I be excused?
You are excused, Mr. Barber.
Thank you, Judge. Have a great.
All right. So position 5 app, that's Bob with represented by app. That's a conflict, right? With the YSL. I'm sorry, what? Co-defendant is position 6. Was Brackley on?
Judge, I'm here.
Okay. So this is 21 SC 178675, Ricky James Lafargue. And pardon me? Well, these are really just announcements. I just want to make sure everybody's here so we can get through if other people can get done. So Brackley's on.
Yes, Judge, I'm here.
Who, Mr. Whitenauer, do you have this one?
Yes, good morning, Judge. I'm here for that case.
I mean, is there anything, is this something we can take care of quickly or?
Judge, I think we can take care of it quickly. The assistant and I have, I'm sorry, Judge, let Mr. Whitnow take care of it.
Go ahead, Mr. Whitenauer.
Thank you, Mr. Brackley. Yes, Judge, I did have an opportunity to speak with Mr. Brackley about the case. The state would be asking that this case be placed on a later case management calendar for this reason, Judge. The state has obtained.
All right, wait 1 second, because the defendant coming in. All right. All right, so this is 21 SC 178675, Ricky James Lafargue. He is present in the courtroom. His attorney, Mr. Patrick Bradley's on Zoom. We have Mr. Whitenauer with the state, who's also on Zoom. Mr. Lafargue, if you have any questions, comments, or concerns that you need to speak with your attorney privately about, you let me know and we'll arrange for that, okay? All right, go ahead, Mr. Whitenauer.
Thank you, Judge. I did have an opportunity to speak with Mr. Brackley about the Lafargue case. I advised him that the state would be obtaining search warrants for his client for DNA, for buccal swabs and hair. Those warrants were signed today by a judge, and my investigator will be working to schedule an appointment at the jail to execute those warrants. For that reason, Judge, I am asking that this case be placed on a later case management calendar. And speaking with the GBI, it's my understanding that if we were to get those samples to them, they could have reports available by late September or early October. Additionally, Judge, I noted in our file for defendant Ba, and I understand he's not before Your Honor at this moment, but I did see that previously his attorney advised that his client might be interested in speaking with the state. I did email Mr. Apt to inquire if that still was the case. And if so, perhaps we could arrange a proffer. I've not yet heard back from Mr. Apt. So it's for those two reasons, Judge, that I am asking that this case be placed on a later case management calendar.
Okay. Mr. Brackley?
Judge, I agree with that. I will discuss with the assistant going forward with respect to that. And I would ask Judge the earliest date possible based upon the assistant's schedule and when he believes it will be done.
Mr. White, now, when do you want to put it back on a case management calendar?
Judge, I would respectfully ask for early October because I do think that the GBI was probably being a little bit ambitious, given that they already have a backlog for DNA testing. So I would ask at any calendar the first or second week of October, as the court pleases.
Okay. Did you hear that, Ms. Robinson? All right, we'll schedule it for sometime in early October.
Thank you, Judge. That concludes my business. May I be excused?
You're excused. Mr. Lafargue, you're excused as well.
Thank
Hi,
you,
Ms.
Judge.
Jones.
And Mr. Brackley, I'm sure that concludes your business.
It does, Judge. May I be excused?
You're excused.
Thank you, sir.
All right. So position 7, Harden, that still needs a mental health. Is that Ms. Jones?
Oh,
All right, so your calendar is different than mine because mine was just printed. Okay. All right, so Terry Harden, which, all right, 7 and 8 on mine, but Terry Harden, who's Ms. Jones. So what? Don't get him yet. I'm just doing announcements. So I appreciate your efficiency, though.
we have been provided this morning, Your Honor, we were provided with an offer. I've discussed that with my client, and we're going to stand on our motion for a speedy trial, which we filed, I think, at May 31st.
All right. I'll bring out Harden in a little bit then for this. Who has this case? Well, this has got to be.
Your Honor, this 88 Clark for the
Clark,
state,
yeah.
Your Honor.
All right, we'll bring out Mr. Harden in a little bit. All
Okay.
right. Position 9, Green. Well, Green, whatever position it is. I know Clark's got it.
Yes, Your Honor, and I filed an entry on Mr. Green's behalf yesterday. Our office will be representing him. He's prepared to go ahead and enter a not guilty plea today. I'd also filed a petition for bond yesterday. I would request it be heard. I understand the district attorney may be opposed based on notice. So if the court's not willing to do that, I'd ask that bond motion be set down at the earliest possible time. I'd reached out to Ms. Peterson about discovering this, and she had indicated that they'll be working to get that to me as quickly as possible. So I can make all that announcement for the record too.
Ms. Peterson?
Yes, Your Honor. So yes, Mr. Clark and I did speak yesterday about this case, and my team and I will be working to get him discovery, I think, next week. I would be opposed to the bond motion being heard today, Your Honor. I think it was just filed yesterday, so I have not had the opportunity to give my victims any kind of notice as required. as to that. So I would just ask that it be set down for a later date.
And yeah, and.
Yeah, so we'll do the bond motion late, we'll set that bond motion for as quickly as we can. Ms. Robinson will print out the paperwork and we'll do the not guilty plea.
I had, I'm sorry, Ms. Robinson, I do have the paperwork, yeah.
You've already got it all done?
Well, I just need to have Mr. Green
Okay,
sign it.
all right. Well, we'll bring him out in a little bit then.
I wasted Ms. Robinson's paper just now, so.
All right, what about position 10, Summerlin? Well, my position 10, Mr. Summerlin. Oh, yeah, I'm okay. That's right. We talked about this. We talked about it.
Basically, he was never booked into the Fulton County Jail, so the warrants are just kind of hanging around until he gets booked into the Fulton County Jail officially, and then I guess closed out.
Who has this case with the district attorney's office?
Your Honor, 88 Clark.
Now, Summerlin have an attorney here present?
Summerlin's attorney is Attorney Rousey. And Ms. Robinson is working on having a production order for the defendant. So I presume, Your Honor, that this will need to be reset.
Wait,
so that
wait, no. Wait.
Mm-hmm.
The way that I understand this case is that he took a plea and he's out, but there are some warrants still due to a glitch because he was never officially booked into the jail.
Mm-hmm.
There are some warrants out there that need to be dealt with.
Yes.
So there is, but when you say production order, where's he being produced
so,
from?
Your Honor, so the defendant, when he took the plea, is in custody, in DOC custody for a probation violation with Forsyth County.
Okay.
And he took the plea with us, but he was never booked and processed on those warrants. So of course, the clerk is going to need those warrants closed out. And so for this particular case, the resolution for it is the production order needs to be done by your court so that the defendant can be brought from DOC custody here, I guess for a case management calendar so that the Fulton County Jail can book and process him. And so those charges and then the final disposition can be reported on the GCIC.
Okay. And Ms. Rousey's not present. Mr. Rousey. Okay. All right. Well, we'll just have to reschedule this and I don't. So and make sure everybody knows that Summerlin's in DOC custody and we have to get a production order for him. Well, my memory's not that good to remember that, but I was under the impression that he was out with warrants hanging over his head.
No, Your Honor.
Okay. Well, there's nothing we can do now, right? I mean, okay.
But it's very important though that he actually be booked and processed because the terms of the plea agreement required that he be given credit for from the date of arrest. So yes, he'll need to be brought in because I think if he is not going to be released on his Forsyth charges until another 2 years.
So I think what you're saying is we can't do this one by the Forsyth Zoom booth, that he's got to be brought over and
right. Yes, Your Honor. He has to be booked, fingerprinted on the charges.
Okay. All right. And make sure Rousey knows, Mr. Rousey. All right. Position 11, Watts. It's Mr. Melnick, right?
Your Honor, 88 Clark for the state. That is Attorney Melnick's case.
So it looks like it was reset due to a pending lab report. Does that sound right, Ms. Clark?
Well, at the last setting, Your Honor, Attorney Melnick indicated that he had not received a copy of the lab report. Since that time, the state did serve him in supplemental discovery, the lab report. And also my notes indicate that Attorney Melnick had said he filed a motion to suppress, but we were in talks of resolving this case. But without Attorney Melnick here, I can't
Yeah,
speak.
no, yeah. I get that.
But he has been served the drug lab.
All right, we'll see if you can get a hold of Melnick. And, all right, position 12, Williams.
Your Honor, ADA Clark for the state. This is my case. Attorney Derek Wright is the defense attorney. He did sign on to Zoom earlier and indicated that he was present at 10:24 in the chat, but I don't see him now. So,
Well, I think he's given us a heads up that he's got a few things going on and he was going to
Okay.
try to bounce in and out. So he's just asking us to hold.
I understand.
Okay. Yeah, these other attorneys, they don't have the luxury of having me full time. Position 13, Warner.
And that's Kimberly Warner.
Yes.
Okay.
It's just announcements, but
Yes, Your Honor.
okay.
This case was on the calendar in July, but because of the judicial hold, it was taken off the calendar. We had filed a motion to reinstate our bond and recall the bench warrant. And we had filed a motion back in July and was hoping to be heard on that today. We received discovery in the case. We've had discussions with the DA's office as to possible resolution of the case. And I think as far as today is concerned, just wanted to be heard on that. And I think the talks have been pretty fruitful as far as possible resolution of the case.
Ms. Clark?
Your Honor, yes, that is my case. Discovery has been served and an offer has been extended. I only ask, Your Honor, for I know that counsel wants to have the motion for the bench warrant hearing today, but Your Honor, I ask that I guess opportunity to pretrial with counsel.
Okay, well, let's do that. I mean, so the bench warrant was failure to appear?
Failure to appear. She's been in there 81 days.
Okay,
So far.
all right, we'll let you talk. I'll take a break and you can talk with Ms. Clark.
Thank you, Your Honor.
All right. Okay, position 14, Harris.
Your Honor, I am present on that. He is currently not competent and is getting restoration services in the hospital. I forget which one he's at.
All right,
East Regional, I'll get it. Yeah.
how much time do you want?
Your Honor, I'd probably just put this in judicial hold, and once the doctors determine whether or not he is restorable or has been restored, we will get those reports. Your office gets those as well, and then we can reset it.
Okay.
I don't know that he needs to just be on a calendar to monitor. I monitor my mental health folks pretty closely.
Okay. Who has this with the state?
Good morning, Your Honor. I believe that my numbers may be different from yours. This is 88.
They are.
Okay.
But it's Desmond Harris, 22 SC 181752.
So that would be me, ADA Amanda Green for the state. I'm filling in for the sexual assault prosecutor in this courtroom. Good morning.
Good morning.
I have no objection to the defense's announcement.
Okay. All right, well, let's put this one on judicial hold till we hear further.
That concludes my business, Your Honor. May I be excused?
You're excused.
Thank you.
All right. Position 15, Trajan Parker. Is this the one that's loaned out as well?
Yeah, so he's actually not loaned out. He is actually picked up in Clayton County for several charges. And I received the list of charges from Clayton County from his attorney, Mr. Bossi.
Yes, Your Honor, I'm here.
So he is actually, Fulton County has a hold for him, but Clayton County has him. But he has not been booked in Fulton County jail for the charges that we have, but I don't know if or when Clayton County will release him, but this is about to tell you.
Okay, Ms. Abbasi.
Yes, Judge, I think they would release him were a CPO done to Fulton County. I don't know how responsive they are to those. But as of right now, unless we have a court date with motions or trial or something which actually requires him to be physical in person, I know he has no interest in being in the Fulton County jail as opposed to Clayton. I think he's a little safer over there. I do keep him apprised of what's going on with this case. And his case going on in Clayton is equally as serious and further along in the process than this one is. So I'm just working through it, and he will be available to come to Fulton County whenever we need him.
Who has this with the state?
Judge, it's ADO.com. I'm having issues with my camera right now. I'm trying to get it on, but for some reason I can't get myself to be shown, but it is me.
Okay. Well, Ms. Oakham, what are your thoughts about this?
Your Honor, I believe the issue is he's in Clay. I believe he has a murder warrant out there as well. The issue we're having is he hasn't been arrested on this case. So whatever happens, whenever he's brought over for his motions or anything, we would have to resolve the warrant issue or the warrant out on this case because he hasn't actually been booked for this particular case.
I don't think that's any problem or anything that, needs to be addressed right away. Whenever he gets there, they'll clear the warrant and they'll clear the warrant.
Yeah, I mean, I'm looking at his charges in Clayton, and one of them is murder.
Yeah. And several of the others are incidents in the jail there. So he's not going anywhere anytime soon. And we have a hold on him anyway.
Well, I mean, I guess what I'm torn about, there's a side of me that wants to, have some progress in it, but I also know he's sitting in Clayton and we certainly have other things to be doing here.
No, Judge, I'm working through the discovery. I'm prepping the case. Whenever we're ready for trial or motions, we can bring him on over. That won't delay the case in any way. It's kind of no different than if he were sitting over in DeKalb or in a different jail. I'm still working on the case actively. I have discovery.
Have there been any motions filed?
Not yet. Discovery is massive. I got the first section of it a few weeks ago. I got the next section of it, I believe, last week, and it's just massive. Instagram, videos, it's a multi-co-defendant gang case. So I'm still working through the discovery to see if there are any appropriate motions. I'm not there yet, able to say whether there are or not.
Let me take a look at this again.
I apologize, Your Honor. I'm back.
Oh,
My
yeah,
system,
no problem.
it kicks me out. I think my internet is having problems. Your Honor, I would also note that this is a co-defendant case, so he does have co-defendants.
Yeah, I'm looking them up right now, actually, while we speak. I see Miss Jones has one of them. Geraldine Mason.
Oh, yes. I do.
Yeah. All right, I think what I'm going to do with this one is, since there's multiple defendants and whatnot, and I'm going to take another look at it, and we'll just reset it for another case management in the future with all of them here.
Okay, I mean, Judge, I guess for future case managements, I'm happy to waive his appearance. Like I said, he doesn't want to be in the Fulton County Jail. I think he's safer over in Clayton, and the case managements were basically just announcing this is the status. It's nothing substantive. So I do have his permission to waive having his presence.
But I hear you that he, but some point with motions and whatnot, I guess we will bring him over and he will be properly booked, and we'll talk
Absolutely.
through that.
Absolutely, Your Honor.
All right. Okay. All right. We'll reset it.
Your Honor, the only other thing I need is that I am court appointed, and in order to get GCICs from the GBI, they need an order signed by Your Honor that he has been found indigent and I am appointed. I can send that over to you. It just literally says just that this defendant is indigent, Ms. Abbasi has been appointed, and then they'll be able to give me the GCICs without me charging back to the county $15 per GCIC.
So you were appointed through the county program.
Yes, sir.
Okay. Yeah. Go ahead and send that over and I'll sign that.
Thank you, sir.
All right.
May I be excused?
You're excused.
Thank you so much.
Well, Judge.
Is that your only case with me?
Yes, Judge.
Okay. All right. Don't, what?
Sorry, Judge.
Wait a minute. Miss Robinson has something going on. Well, that's what I was just saying. Yeah, like in the future, we're going to do a case management with all the co-defendants. Okay. Yeah. We're going to schedule a special calendar in the future with all the co-defendants and work through when we can try the case. So.
Fantastic. Perfect.
Okay. All right, Ms. Holcomb, you're excused now.
Thank you, Judge.
All right.
Thank you, Judge.
Bravo. All right, position 16, Shalaka Young.
And
That's the one that hasn't been booked.
No, they were waiting for some.
Oh, yeah.
this came up in the context of a motion to reduce bonds. The state represented that there was an outstanding warrant for DeKalb that I wasn't aware about. Ms. Clark has gotten me information on that warrant. Part of our presentation to the court back in July was that she was going to have treatment available to her if the bond was reduced and an organization could go on her bond. Given that this warrant is pending, that's not really an option anymore.
Yeah.
So I don't know if I can't remember if Your Honor had ruled on the motion to reduce bond or not. Either way, it's not going to be necessary at this point. I've discussed that with Ms. Young. We can bring her out. I think she has a final plea date set. All our position is at this point is we'd ask it be left on that final plea while we explore a resolution with the state.
All right, Ms. Clark.
Yes, Your Honor. The state is not opposed to it going to a final plea calendar. The defense has been served discovery and an offer has been extended. We are opposed to the bond being reduced for the reasons we set forth in the last hearing. And nothing further, Your Honor.
Yeah, I don't have it in front of me. I vaguely recall. I don't think I would have reduced the bond. I would have either said no or reset it until after
Okay.
we.
Well,
seems
Your
like
Honor,
that would have done.
the reasons that we asked is because the defendant has a involuntary manslaughter warrant for a warrant out of DeKalb County for that.
Yeah, I've got that in front of me.
And based off of the fact that our victim is an elderly man, and what was done to him, as well as the extensive criminal history of the defendant, the state is of the opinion that definitely the defendant doesn't need a bond because she is a risk
All right.
to. Mhm.
Yeah, I mean, I think we're all on the same page. So no on the bond reduction or denied, and we will leave on the final plea count.
And Your Honor, if I could add, I don't know. I was looking, Ms. Clark. I don't believe I've received an offer, at least just checking through my email and discovery again. So if you had sent it, I'm not sure where it's at. I just ask if you could send that again.
Of course, sure. I will get that to you.
Okay. All right, next one is Denisha Rosser. Okay.
Yes, this was a probation revocation reset. We had requested a hearing. I've since had a chance to talk with Ms. Iqbal, and this will be for stipulation. We've worked it out.
That is correct,
Your Honor. Good morning.
We'll do that today?
Yes, Judge.
Okay. Okay. Position 19. Well, my positions are irrelevant at this point, but Chalel Francisco.
Good morning, Judge. Lauren Brown here for Mr. Chalel Francisco.
Okay.
Filed an entry of appearance and demand for discovery, as well as he had been picked up on a bench warrant from arraignment. I did file a waiver of arraignment, Judge. I did also file a motion to recall his bench warrant. It's a pretty simple demonstrative reason that he did not get notice. I'd love to take that up. I have the surety here present today. We would not be ready for trial at this point as I have not been served discovery, but I really would like to take up that bench warrant issue as it's very easily demonstrative how he did not get notice, Judge.
What's your last name again? I'm sorry.
Brown, sir, Brown.
And who has this with the state?
Judge Shama Iqbal for the state.
Where's Chalel Francisco right now?
Should be in the back.
Oh. All right, give me a minute. We'll take that up though, at least the bench warrant.
I appreciate that, Judge. Thank you.
All right. All right, then the additional position 20, which is Y03225, Mr. Wilson.
Good morning once again. Ekebe Kuru on behalf of Mr. Wilson, who is present.
And Your Honor, if you could ask counsel to come to the podium because
She came up. She was
Okay.
talking on the way to the
All right.
podium. So.
Thank you.
Yes, Your Honor, as I stated, Ekebe Kuru on behalf of Mr. Wilson, he is present. This is just a motion to vacate a bench warrant. It shouldn't take more than 5 minutes of Your Honor's time. We would just like to address that.
Ms. Clark?
Your Honor, we can address that. The state doesn't oppose being, but we would also like to be able to understand and be provided a reason for why the original failure to appear happened, as long as we can.
Why don't you bring your client up? I mean, this is the last thing on the calendar, so let's just roll with this right now.
Thank you, Your Honor.
All right, so this is Y03225, obviously a very old case. And go ahead.
Yes, Your Honor. This case originated back in 1997. It's a case of forgery. Mr. Wilson was a student here in the Atlanta area, residing with his aunt when he was accused of writing a bad check against, I believe, his cousin, if I'm not mistaken. He was arrested on these charges. posted bond, bonded out, and moved out of the home because I believe the cousin was residing there as well. He moved out of the home, and unfortunately, he just did not receive notice back in, I believe, 2000 or 2001, when this case came back up on a calendar. So he was unaware that this bench warrant had been floating around. It wasn't until sometime this year when he found out that the bench warrant had been active for over 20 years. Since then, Your Honor, he has not had any run-ins with the law. If so, he would have been made aware about this bench warrant. When he was made aware about it, he contacted our office and we filed the motion to vacate the bench warrant.
How was he made aware?
He went to apply for a license to carry. And they did a background check and they found out that there was a warrant for him.
But he voluntarily reached out to you.
Yes, Your Honor.
And
He
is
reached-
voluntarily standing here.
Yes,
on
sir.
his own.
He reached out and we reached out to the court, who gave us the proper case number and also alerted us to know that it'd be in your courtroom. So we filed that motion to vacate the bench warrant.
So what are you asking for now?
Your Honor, we're asking that the bench warrant be vacated.
Obvious. You said it 3 times and I just, Ms. Clark, what's your response to this?
Your Honor, the state does not oppose since the defendant is physically here at present with counsel. And because of the age of the case, we have no opposition, Your Honor. We'll defer to the court.
Okay, I'll vacate the bench warrant. I guess if this was on hold, I'm assuming, I guess it comes off hold and you'll have to discuss with the state potential resolutions to it, but I will vacate the bench warrant. So can you get me an order on that?
Yes, sir. I'll have that emailed to your court, to your
Okay.
office.
All right.
Thank you, Your Honor.
All right.
And counsel, will you also copy me on that as well?
Absolutely, Ms. Clark.
Do you have Ms. Clark's contact
Yes,
info?
sir, I do. I have her email address.
Okay.
Thank
And-
you.
Judge, I'm sorry, may I have the defense attorney spell her last name?
I sure can. It is spelled Ekure.
Thank you.
Thank you.
And like I said, I know you know this, we're just vacating the bench warrant. You still got to figure out how to resolve the underlying matter with the state. So,
Thank you, Your Honor. And I'll have that ordered to you this afternoon.
okay,
And-
thank you.
Yes, sir. That concludes my business. May I be excused?
You're both excused.
Thank you. And thank you, Ms. Robbins.
Thank you. Okay, so let's see here. So we dealt with 1, 2, and 3. 4 we've dealt with. 5 we dealt with. 6 we've dealt with. Let's go ahead and bring out Terry Harden.
And Your Honor, Juliana Peterson for the state. Could I just get some clarity? James Green was my only case on the calendar. Are we bringing him back out for some kind of announcement or discussion?
Yeah, I apologize, Ms. Peterson. I probably would have done this next. I forgot you're sitting out there. I mean, he's going to, I assume, Mr. Clark, have you gotten him to sign his not guilty paperwork yet?
I haven't. I can go back there.
If I
If
leave?
if we can just tender this as a waiver, I can get them to sign off.
I have no problem staying on, Judge. I just needed to know.
No. Yeah. Mr. Clark, so you're saying that you're waiving
He would waive formal.
thank you.
arraignment or not
Waiving
guilty.
formal arraignment
Yes.
and pleading not guilty, and you'll file that paperwork.
I'll get him to sign this. If I could, I have the indictment. Would I be able to sign with your permission, Miss Peterson?
Oh, of course.
Okay, so Mr. Clark's going to have him sign that and file that with the court. You're excused,
Okay.
Ms. Peterson.
Thank you so much, Your
All
Honor.
right, thanks. Bye-bye. Okay, so this is two cases, 23 SC 186-192 and 23 SC 186-131. Mr. Terry Harden, who's present in the courtroom with his attorney, Miss Tanya Jones, and we have Miss Clark here with the state. Well, she's appearing by Zoom. Go ahead, Miss Jones.
Thank you, Your Honor. This was on for case management calendar because we have filed a speedy trial demand. I did receive an offer from the state. At this point, Mr. Harden is not going to take that. So we will stand on our motion for a speedy trial, which was filed, I think, at the end of May. And I know my client, speaking with him today, he would like a bond reduction. If Your Honor would like to hear that today, or I can file the appropriate motion.
Ms. Clark, so what was the offer?
As to count one, it would be 3 years confinement. Count two, 3 years confinement consecutive. 23 SC 186-131. I don't have my glasses. 3 years, must complete RSAT and then balance probated. So essentially 9 years.
The last 3 years, Your Honor, is probation.
Upon completion of RSAT.
And what are the maximums on these charges?
5 years, Your Honor, for each charge.
Okay. So
But
if,
but the offer was based off of the defendant's criminal history, Your Honor.
well, I sort of figured that. So, Mr. Harden, obviously, if you go to trial and you're convicted by a jury, you could be facing 15 years.
Yes, I understand.
Okay. And you've got an offer for 6 years if you complete RSAT with 3 years probation, if not 9 years, correct? Okay. When
And Your Honor, I understand that the speedy trial has been filed, but the case would need to advance to a final plea calendar before it would be set on the trial calendar. Or you can set a trial calendar at the same time, but it just gives, the final plea calendar gives opportunity for, the defense if they want to try to negotiate or set
yeah,
a
I mean,
counteroffer.
I know what a final plea calendar does.
I know, I just was reminding you, Your Honor.
That's.
Yeah, we would request September because of the speedy trial demand. That's September 20th.
That's a 2 week, is that a 2 week calendar?
You can give me a
All right,
little
2 week
bond.
calendars for now on, every time. I always want those. Please, please. '26. Did you block it out on the email calendar? I mean, on the Outlook calendar? Wait a minute, I don't see. I'm looking at Odyssey. What? Wait a minute, when is the trial calendar? I thought it's the 31st. Oh, you're saying that we need to say something to Elizabeth if we want it to extend for 2 weeks. What about the August? Is that set for 2 weeks? All right, we need to, and do it on Outlook as well. I mean, block those dates out because I want those things locked down. We've got too much going on the criminal side that we've got to have at least 2 weeks a month of criminal trials. We can't go light on it. It's just too much. For 2 weeks. All right, well, a week and a half is all right, but let's I mean, start reaching out and blocking out 2 weeks because we'll have to load up. So well, yeah, but we'll just get a different court reporter. I'm not letting, I mean, all due respect to Ms. Meyer, I mean, I want to let that hold up the calendar call. Wait, a trial calendar. We got to start blocking out 2 weeks. It's got to go on Outlook and we got to roll with it. But let's deal Mr. Harden right now. Do we have anything specially set for the end of the month? Yeah. All right, let's discuss this with Ms. Clark. You know, obviously there's a statutory speedy trial on this case. How quickly could you try it?
Well, Your Honor, I need to check, but I'm not sure are you making a constitutional demand or a statutory demand?
It was a statutory demand.
Yeah, I looked at it just a minute
Okay.
ago.
Well, Your Honor, based on what the state already has on this calendar and the calendar for next month, we would need 60 days.
I don't know about that. I mean, I was trying to, I mean, because we may put this in a number one spot. I mean, I was thinking about either this month, August 31st, or September.
Your Honor, but the trial calendar is already published, and so with a published trial calendar, cases can't be added.
Well, I can revise the September one. I mean, the August, maybe not.
Okay. But it's not, yeah, but the trial
I mean,
calendar.
you're in, I mean, you've got you've got the statutory speedy motion as well, Ms. Clark. I mean,
I understand, but it's the two terms, and
well, I'm just saying we've got an opportunity.
We don't object going on the September 18th docket. That's.
yeah, I'm not opposed to that either. I'm just saying not this trial calendar.
All right, let's see here. All right, let's put it on a September 18th.
Sounds good.
All right.
And Your Honor, in regard to lowering his bond, can we address that today, or would you rather have me file a bond reduction? We had a little miscommunication. I thought he was going to be able to make it, but he indicated he's not going to.
please? Please. Well, Ms. Clark, Ms. Clark, did you hear that?
Yes, Your Honor, the state would just needed to be reset. I need time to notify the victims, Your Honor.
Okay, we're gonna have to reset that and have you file.
Okay.
All right, we'll put this on the September calendar. Thank you. You're excused, Mr. Harden.
Thank you, Your Honor.
Thank you. So position 9, we've already taken care of, right, with Mr. Green?
Yes, Your Honor. Could I approach,
Yeah. Let's see here. Not guilty.
No, I just have,
Okay.
And that concludes my business, Your Honor. May be excused.
Yeah, you're excused, Mr. Clark.
Judge, may I make an announcement?
Yeah, sure, Mr. Mellon.
Rodriguez Watts. I wasn't sure if that case, I saw that Ms. Dixon had filed a null pros. Sorry.
Wait, are you following this, Ms. Clark? Just so you know, this is.
I hear Attorney Melnick. I'm listening, Your Honor.
Okay. Just want to make sure you are literally on the same page. So.
Okay.
But I got that, and I wasn't sure if that was a null pros because they re-indicted the same case, or if he was indicted on a different case.
Yeah, and I got this. The other day, yesterday. I'm not sure.
Do you know, Ms. Clark?
Oh, so the case, it's the same case. It was just re-indicted for the new numbers 23 SC 186417.
Okay, I'll get that off of Odyssey. And Judge, I have a motion to suppress my client's statement. That I think maybe I filed under the old indictment, but it would carry over to the new indictment. So we'll need a motion state as soon as possible. He is in custody, but he's in custody on something completely unrelated.
Okay. So you have, you've gotten a lab report now, right?
I'll be candid, Judge. I don't remember seeing a lab report. The primary issue here was the firearm charge. Ms. Clark, do you see if a lab report is coming?
Yes, I had my legal assistant to serve that to you right after the court on the last hearing.
Okay.
I can have her do that again. But also to Attorney Melnick, I think that I guess we were also, I know that we were supposed to set it for the hearing for the motion, but also we were kind of talking about trying to resolve it.
Why don't we do that? Why don't we put it down on a motions date, Judge? But in the meantime, I'll reach out to Ms. Clark and hopefully we can get the case resolved.
Okay. Let's put it down. Let's put down for a motion date on his motion to suppress. All right, Ms. Robinson. Okay.
Thank you, Judge.
You're excused.
Thank you.
All right. All right, trying to think what else we have left.
We have a small bench warrant issue for the next to last case.
That's right. Let's go ahead and take that up. Bring out Miss Warner.
It's Chilel Francisco.
Oh, sorry. That's right. We've got a couple bench warrant issues to resolve, but Ms. Iqbal, you still there?
Yes, Judge, I'm here.
Okay. All right. So they're getting Chile Francisco? Yeah.
May I have the defense attorney's name, please?
Her name is Lauren, Lauren Brown, like the color.
And does your client need an interpreter or is he?
It's not,
Okay. Is everybody in the audience that you're here, if you at least heard your case be mentioned or why you're here? Okay, just want to make sure you're in the right courtroom. We'll get to it. Okay, so this is 22 SC 183294. Mr. Transito Chile Francisco, who is accompanied by his attorney, Mr. Brown. They're both in the courtroom as Iqbal is present by Zoom. Go ahead, Mr. Brown.
Thank you, Judge. Mr. Chilel Francisco is here and in custody because he was arrested on July the 25th.
Judge, can we have Mr. Brown speak into the microphone, please?
Yes, can you hear me now?
Yes.
Yes. Mr. Chilel Francisco is here in custody after being arrested on July 25th, 2023 on a bench warrant that was issued after an arraignment date was missed in March of 2023. I believe that bench warrant was issued in or around the date of March the 28th, 2023. I have two basic reasons I would like to demonstrate to the court that would show that, one, Mr. Chilel Francisco did not willfully miss court, and two, that he actually is not a flight risk or has not been avoiding court. The first of those, Judge, is I believe the notice as indicated in Odyssey went to an address of 1238 Low Lane. That's in Roswell, Georgia. The actual surety for the case, Judge, is present and behind me. His name is Mr. Eddie Rogers. And that address at 1238 Low Lane is an old address that Mr. Chilel Francisco had resided at. As recently as yesterday, we did visit that particular address. It's been knocked down and they're building a housing development there of townhouses. That's not a good address anymore. The Low Lane has actually now been converted to a new street called Harper Drive. I have the actual address where my client lives, but that address is not even an address. He moved away when the property had been acquired and they started to build townhomes, as is routine in the metro area now. Additionally, Judge, at the time in which he was originally arrested on the warrants that encompass this 22 SC indictment, he was also arrested for a DUI. That DUI was accused and was assigned to Judge Edie. Mr. Chilel Francisco, along with the surety, who is a friend and a tie to the community, Mr. Eddie Rogers, I mentioned before, secured an attorney for him at the end of 2022 for that DUI. And I have the case number, and it's obvious on Odyssey that he was attending court dates for that particular charge, including a court date in which he resolved that case with a plea on April the 12th, 2023, after he had missed arraignment and after the bench warrant had been issued. So my point, obviously, Judge, is he's still coming to the courthouse to resolve cases. He did not have an attorney, did not have me on the 22 SC case to inform him about court dates or have the know-with-all to look on Odyssey and check status of cases. But he came to court on April the 12th, 2023, entered a plea on that case. Odyssey also evidences a time in June the 14th and again on July the 6th, both 2023, after the missed court date and after the issuance of the bench warrant, in which he reported to probation in person, provided updates on his progress for his DUI conditions, and made payments against his fines. Judge, I can go into all IALA factors and things of that nature, but I think for those two reasons, I think we can demonstrate, and of course I'll supplement that he didn't receive notice because the address on file is not a real address anymore. And likewise, Judge, he's been coming to court for a different case while during this pendency. He just didn't know. And now he has me. I will make sure he's here, Judge, and that's my duty as his representative. So I'd ask for you to recall the bench warrant and reinstate his original bond. On the motion that I filed, there is a proposed order to that effect.
All right, Ms. Iqbal.
Judge,
Sorry, what?
I'm gonna leave this up to.
Go ahead,
Judge,
Ms. Iqbal.
The only thing I want to put on the record is that defendants have a duty to update their address information, and this defendant failed to do that. However, I do agree with what defense counsel is saying. I did see in Odyssey that he did resolve that case earlier this year. He has been going to court. So I don't really take a position one way or the other, Your Honor. I'm going to leave it up to the court's discretion.
Okay, so and what's your request now on the bench warrant, Mr. Brown?
I sent a proposed order, Judge, as a part of my motion. So I'm asking that you would sign and file that motion. Is to recall the bench warrant and reinstate the original bond. No forfeiture proceedings have begun.
Okay. I'll do that. I'll recall the bench warrant. I do want to emphasize to your client. I know you mentioned earlier, Mr. Brown, that it's proof that he didn't willfully. Ultimately, Your client, Mr. Chile Francisco, it's up to you to stay up to date with your address. I don't really care whether the building's torn down or whether it's still there, or it's not there. It's just that you had the wrong address in the system, and that's on you. And so I would expect, not like I told Mr. Brown, I'll sign that order, but I would expect that you, well, I guess that at the earliest time that you can, go to the clerk's office and get your address updated. Okay.
We'll get that done immediately.
I
Judge.
see his.
And can we have the address on the record too as well, please?
Of course.
Yeah.
Give me just one moment. The correct address is 81 Parkmont, Parkmont Drive. That likewise is in Roswell, Georgia, 376.
Thank you, sir.
Okay, just to be redundant, Mr. Chile Francisco, when you're out on bond, you gotta make sure that your address is up to date, because then, and I know you've got an attorney now monitoring it, but then when it's not up to date, you don't get notice, and then we do a bench warrant, and you have to stay over at the Fulton County, spend some time there, which I'm sure you don't want to do, right?
No.
Okay, all right. I'll sign your order.
Thank you, Judge, and thank you, Ms. Iqbal.
Okay, thanks.
Yes. And Judge, I do think we have one more, I have a case with Miss Jones, where we stipulated to the probation.
Oh, yeah, the probation revocation?
Yes, sir.
Which one is that?
It's Rosser.
Okay, I've got that. Yep. All right, let's bring out Rosser. And do you have that warrant the order that you printed? Okay, all right, well, good. I'll sign it right now.
Judge, I'm gonna step out and speak with the ADA on the warrant case.
Okay. That's right. We got a lot of,
Several orders to be signed.
this is the one that Brown just did, order recalling defendant's bench warrant.
And that's the one from Ms. Field.
Okay. Good. There you go. Okay, this is 17 SC 153972, Denisha Rosser, who is present in the courtroom with their attorney, Ms. Tanya Jones. And we have Ms. Iqbal with the district attorney's office on Zoom. Go ahead, Ms. Jones.
Thank you, Your Honor. As indicated before you is Ms. Rosser. The state is alleging that she committed a new felony in Clayton County. We will stipulate by preponderance of the evidence, not proof beyond reasonable doubt, that she is in violation. State's recommendation is to revoke 60 days, Your Honor, reinstate her probation. She has been in 63 days, and that she be supervised for 3 years. And if not already on her probation order, I was going to look at the disposition, but if it's not, she's supposed to maintain mental health medication compliance, Your Honor, medication compliance. She is currently on her medications. The jail has been giving them to her. And once she's released, she goes back to Grady to get her prescription rather filled.
And does she have a mental health probation officer already?
Yes, Judge. She does.
Okay, well, maybe I'll be redundant. We'll add it to it.
Yes, we would request that she be supervised by a mental health provider or
Okay.
probation officer.
Ms. Iqbal?
Judge, one more thing, Ms. Jones is correct. I would ask to put conditions being must remain medically compliant, have a mental health probation officer, stay away from the Amazon warehouse where she worked. That's where the incident occurred. So I'd ask that, and Judge, this revocation, from my understanding, is based on the same victim in a previous case that we null prossed. So this is technically her first revocation. She did have one previously, but we null prossed that case. And so I think is that these two people stay away from each other. And so I believe the incident happened at our work, which was Amazon. And so if we do a stay away, I think
Yes,
that
and
might.
I talked with my client in regard to that she's most likely lost her job at Amazon at this point because she did come from Clayton County to find something else to do, because being around this person, it's just not good. And she's ended up in jail twice now. So, so I've discussed that with her and she has no issues staying away from the Amazon.
Sure. Do you have the address of the Amazon warehouse, Ms. Iqbal or Ms. Jones?
I can look it up. Is
I would assume it's the distribution center.
is it the one in Doraville or?
It's good.
My client's telling me Forest Park.
It's a good assumption. I think half the world is Amazon distribution centers now. So
Is it 2125 Anvil Block Road, Forest Park?
My client's indicating yes.
Okay. So yes, Judge, 2125 Anvil, ANVIL Block BLOCK Road, Forest Park, Georgia, 30294.
okay. Okay. I will agree to revoke for 60 days, reinstate probation, supervisor 3 years by a mental health probation officer. She's to remain in compliance with her medications. And she's to stay away from the Amazon warehouse where the incident has occurred, which is on Anvil Block Road in Forest Park, Georgia. Is there anything else?
Not from the defense.
Nothing more from the state, Your Honor.
All right, you're excused.
And Judge, I believe that concludes my business. Of course, I can jump back on if need be, but may I be?
I think you're probably done.
Okay. Thank you, Judge. I guess I'll see you guys tomorrow.
All right, we'll see you tomorrow. What else do we have? We've got that other bench warrant with that attorney, right?
That concludes my business. Your Honor. May I be-
You're excused. Have a good day.
I think there's one. Bench warrant issue.
Is that Lewis? Yeah, bench warrant motion. Is that it? Is that the only one that's left? The Warner, Kimberly Marie Warner? I guess just let him know that I mean, we're waiting on him at this point. Sure.
I believe we're also waiting on Attorney Wright for the Octavian Williams case, Judge.
Oh, yeah. Well, we were hoping he would yeah, we were holding for him to report. Have you heard from him? Must be with a judge that's meaner than me. Well, I guess I'll tell you what, bring out Octavian Williams. Just to let him know what's going on. Yeah. Mr. Williams, just bringing you out to let you know that your attorney, Mr. Wright, had a conflict. So we're not able to address your case management today, and we will address it at another moment, at another day, okay?
Your Honor, 88 Clark is here. I was on the phone with Attorney Lewis.
Okay. It'll probably be in 30 days. All right. All right, you're excused. So we'll reset this for 30 days.
Your Honor, the defendant has two.
I mean, if he
cases.
magically appears, we'll see if he's still here, but go ahead, Ms. Clark.
I have a question. So the defendant, the two cases, I guess, were re-indicted under this one case. Okay, I just want.
Which case you talking about?
Octavian Williams, because I know
Yeah.
he had two cases, but I think, okay, just disregard what I was gonna say. Because I know he had a second case, but I forgot they were consolidated.
And you've been talking with Lewis on the Kimberly Warner?
Yes, we just got off the phone. I had told him I was gonna call right back because I didn't want you to call for me and I wasn't available.
Well, that's the only case we're waiting on right now.
Okay, so I'm gonna just call him and tell him to step back in the courtroom.
Okay, thank you.
Yes, sir.
All right, bring back Octavian Williams. Who has that case with, is that yours case? Okay,
Yeah,
we're bringing back Octavian Williams.
All right. But Your Honor, that is my case.
How are you, Mr. Wright?
Good afternoon, Your Honor. I'm sorry I was in Rockdale when I signed in before and it looked like I was early.
We got one more thing to do. Sorry, that's all right, Mr. Wright. I understand. Okay, all right, so this is 23 SC 187104 Octavian Williams, who is present in the courtroom as attorney. Mr. Wright is on Zoom, and Ms. Clark with the district attorney's office is on Zoom as well. So, Mr. Williams, if you have any questions or concerns or thoughts that you want to talk about with your attorney privately, let me know and we'll arrange for that to happen, okay? He wants to talk to you, Mr. Wright.
Okay, well, tell him I guess if we can do a breakout room, otherwise I'll be at the jail this weekend. So if it can wait till the weekend, then I'll come see you.
Well, what's the announcement on the case management first?
Your Honor, I think I have the discovery. He has several cases, so I'm sort of a little bit uncertain to make sure I have everything in all his cases. I'm hoping maybe to get a global resolution, get everything cleaned up and get him situated. I want to say there's 2 or 3 open cases.
Okay. All right. So is this on a trial calendar yet, Ms. Robinson? Well, let's put him on. How much time do you need to go?
I can be ready relatively quickly. In fact, my next question was going to be, depending on whether I'm going to be in your court, Your Honor, on the 28th for Troy Pitts, I can be ready, sometime in September or even early October on this case. But I'm thinking maybe September, if we can figure out a resolution and
all right,
clean everything up for Mr. Williams.
Let's put Mr. Williams down for the September trial calendar. You got that, Ms. Robinson? And Mr. Wright, you can contact your client down at the jail to talk to him about everything.
Okay, I'll see you, Mr. Williams, this weekend. I'll probably be there, maybe Saturday, but more than likely I'll see you Sunday morning.
Okay.
Attorney Wright, do you have my contact information?
No, but I was gonna say, if you want to give it to me so we can talk, I would love to.
Okay, I'm gonna put my email address and my cell number in the chat.
Because I
Okay.
know that previously, ADA Burnett was, had communicated with you and, had discovery served to you. I don't think an offer was extended. But I'm gonna put that information in the chat now.
Okay, and again, I know he has what, at least 2 cases, so we can make that a global offer. That'd be awesome.
Okay.
Okay. Well, let's bring out Kimberly Marie Warner.
Judge, as that concludes my business, may I be excused once I,
Yeah, you're excused once you.
Okay.
All right.
thank you, Judge.
You're welcome. Okay, this is 20 SC 176-964 Kimberly Marie Warner, who's present in the courtroom with her attorney Reginald Lewis. And we have Ms. Clark with the district attorney's office on Zoom. Go ahead, Mr. Lewis.
Good afternoon, Your Honor. We filed a motion to recall the bench warrant and reinstate bond in Ms. Warner's case. This case stems from a June 8th, 2020 arrest for aggravated assault and battery, family violence, stemming from an incident with her son. She missed court on March the 14th of 2023. That should have been a final plea in her case. At the time, she had obtained private counsel, and during that period, or leading up to that period, her relationship with her counsel had become somewhat estranged as far as the communication is concerned. As far as the notice for that particular hearing, in checking Odyssey, the address listed was the address where the incident took place. And so she, due to bond conditions, could not be at the address where the incident took place. And prior to that, the notices was given to her directly from her attorney. Her address at the time was her mother's address, which is a 5874 Green Meadow Way in Rex, Georgia. And in fact, the notice for this particular hearing was sent to that address. And the position as far as her missing court on that day, she just simply had no access to the mail that was sent to that particular address. And her counsel, they had just kind of lost communication. She has since, of course, obtained new counsel. I think her former attorney is tied into the YSL case, and just been extremely tough for even me to get in touch with them to discuss kind of how we got here. We've received discovery in the case. We've been discussing resolution of the case. We've cleared up any issues that there may be as relates to her address with the clerk's office is clearly being sent to the right place. As far as.
Well, that was going to be my question. I mean, if the bench warrant's lifted, what's her living arrangements going to be?
With her mother, the same place. It's the exact same place that she was. After the incident, she moved in with her mother. And she's also the caregiver for her mother, elderly mother.
Oh, so the problem is that it was going to a different address that she was ordered to stay away from.
That's where the mail was going.
Okay.
The mail is now going to
the correct one, her mother.
5874 Green Meadow Way, Rex, Georgia, 30273.
All right.
Um,
Let me just hear from Ms. Clark on this real quick. What's going on, Ms. Clark?
Your Honor, so I had an opportunity to talk with Attorney Lewis regarding I guess the confusion with the address. My only response to that is I will defer to to you, Your Honor, on what you decide to do. I will say that it is the defendant's obligation to notify and update the court clerk with the most appropriate address. That is one of the bond conditions.
And so that's my only thing on that. Also, Your Honor, there was an immunity motion filed in this case as well. And I know this court had reset it, and so that would also be something that the state would need to know whether or not the defendant will be proceeding with the immunity motion.
All right, Mr. Lewis.
We haven't made a decision as to whether or not we're going to proceed with the immunity motion filed by our former counsel. But that's certainly something that we'll be making a determination here in the next week or so. And to one last comment as far as the address. There wasn't a change of address. From the moment she bonded out, her address was her mother's address, the Rex, Georgia address. So it's not like she got out and then changed the address. She was getting out to go and live with her mother, and she's lived with her mother since then and will continue to live there. So it wasn't, she got out and changed the address. That was the address she was being released to.
Okay. So
But the address of record with the clerk was the wrong address.
That's what I'm saying, Your Honor.
So, and I'm not, so what are you asking, to lift the bench warrant?
Lift the bench warrant and to reinstate the bond. We've talked to the bond company, according to a second, the bonding company, the bond's still in place. And we'd ask the same conditions of her original bond be in place. And specifically those conditions, no contact with her son. She can't go over to the house. And other than missing that court date, she's complied with all the conditions of that bond. And we ask that those be reinstated.
Okay.
And Your Honor, also just to add the last, so the Rule Nisi hearing was supposed to be held on July 13th. And that was when Attorney Lewis did make an appearance on the defendant's behalf. And so you set it forth for this date. So just wanted to let you know how that part, as far as the actual motion, the court decided to hold off on having the bond forfeiture hearing in lieu of the fact that she had hired new counsel.
Okay. All right. All right. So I will, I'll agree to lift the bench warrant, reinstate bond. As I told somebody else that got a very similar situation, it's ultimately up to you, Ms. Warner, to stay updated with the clerk as to your address. Certainly, if I was in your shoes out on bond, I would probably be, from an OCD standpoint, checking it every day. Sure. But I don't know if that's necessary, but you've got to make sure that your address is proper with the clerk's office. Because if it's not, if you move away from your mom's and it's not the correct address, this is just going to happen again. And you don't appear like you like that happening, correct? Okay. All right. Well, I'll agree to, did you send an order over already?
I prepared one.
Yeah, you go on and bring it over here.
Attorney Lewis, did you also have an order for the reinstating the bond?
He
Or
does.
just-
They're both, they're
Okay.
combined.
Okay.
Well, I guess I'm not following. These are just two copies of the same one, right?
Yes, Your Honor.
Is there something wrong with this one? All right. Well, regardless, what you're excused. If she needs to change it, I'll sign it. Is that it?
That's all from the state, Your Honor.
All right.
Thank you, Your Honor.
You're welcome. We're adjourned. Are you writing them on there? All right. So 2 o'clock, we have the plea. Sure. I'm glad y'all caught that one. Well, that would not have been good. Lafargue is going. We've already had Lafargue out here. He's gone. All right.
Ms. Robinson.
Guess I'm the only one here. Huh? Are we going on at 2?
Yes.
All right. You don't have to. I'll come back. Where's Miss Robinson?
Judge? Oh.
Who is? Just so you know, I'm waiting to get in. That's all right. What is your name? Daniel Brown? Dana, nice to meet you, Dana. Okay. Okay. Oh, you got a good memory. You got a good memory. Uh-oh. Took advantage of the new guy, huh? Okay. Oh, yeah. Yeah, there's always something new. There's always something new. Yeah. That's true. So whose courtroom are you out of normally? Schwal? Dunaway. Oh, yeah, I know both of them quite well. Yeah, Judge Schwal is out for a few weeks there. He is. Right. No, they don't like me hanging out here when they're not here. I'll go back to my chambers until we're ready. Pardon me? With me? Okay, I'm the one that's holding it up. All right.
Okay. Sir, you gotta step out for a moment, okay? He can let him continue to sign the paperwork when he get done. Okay, so I'm going to, put this on.
For some reason, I'm able to have this on my phone, but my computer, I can't, I don't have the link on my computer. Let's see. That's not
Edie
what
Jenkins.
Yes.
This Christinia. Miss Robinson just sent an email out saying, well, she copied you on it as well, that the deputies asked them to leave the courtroom, some emergency, is what she said.
Okay. First of all, thank you.
Yes, sir.
All right. So there's some form of emergency going on down here at the courthouse that that the judge had to leave for. Okay, I just got some kind of alert. Okay, here, Office of District Attorney. I don't know what this is technically. Hold on. It's supposed to be some protest or something. Hold on. You are reminded to notify command. Okay. All right, now that's just, I don't know what's going on here. Other than we was just told we have to go. Let me see what's going on with hold up. Let me see what's going on. Can you guys hear me? Is there something going on?
They're kicking us all out.
Well, I'm in court
Is it?
technically.
Yeah.
Hold on.
George, I can hear you.
Okay, you can hear me? All right. I hear his voice. Yeah, we're in court right now, but it looks like, I don't know what, we've got some kind of
What?
Is there some kind of alert going on or something?
They just want to know who's up.
Oh, okay. They did, yeah. Yeah, I'm in my office on Zoom. And Whitney, they're all around the corner right here. I think, yeah. You guys have enjoy.
I think Keelan's still in the building too. I don't know if anybody. He was right here too. There.
Well, you guys enjoy. Get a drink for me.
Yeah, I need one.
Hey, Brad, can you hear me?
Yes.
Hey, man, do me a favor. Can you email me the link?
Yeah, sure. Let me see if I can do that.
I'm trying to bring it up on my computer, but I'm on my phone right now. Really weird, man. Okay, what's going on here?
All right, I just sent you the link, and the email might say it's from Christinia, but the link is in there.
Hold on. All right, hold on. All right, Brad, hold on, bring it up. Ah, okay. This is the one I didn't, right, okay. That, yeah, whatever she sent before, I didn't, okay, now I have it, hold on. I know that. Zoom in on both. But nothing from Mandeli.
Hmm.
Like I said, unfortunately, I didn't get to able to reach out, and I dropped the ball on that. But I mean, he
Mhm.
knows.
See a lot of deputies in the courtroom. Is that a dog in the courtroom?
May have seen one.
Hey, George, what did I miss at the lawyer leadership meeting with Fonnie yesterday?
Oh, it was a another basically wind down Wednesday opportunity.
Oh, okay.
Yeah.
Mhm.
So, and I've already been on that project for 2022s, and so she had some boxes for 23s, and that and there's another meeting next week. So
Well, that's good if we're into the 2023s.
yeah. Well, that doesn't mean we're done with the 22s. We're just getting into the 23s.
Oh, okay, yeah.
Right. So just be prepared for next Wednesday. It's
Okay.
another day.
Okay.
How are you feeling, man?
Getting better. Still not up to par, but getting there. Getting there. Were you able to get the plea docs from my office in
Yeah.
case he shows up?
Yeah, I got it.
Okay, good. All right, good deal.
We're good. You see him on Zoom here? I don't think. Oh, there he is. He's in the
Wow.
court.
Wow.
Okay.
Mr. Mondelli, how you doing? Can't hear you, but glad to see you.
All right. Well, he's there. All right. Let me check and see if this guy's.
The podium microphone isn't on, so we won't be able to hear you until Kathy unmutes that.
Okay. That was up earlier. Hold on. I don't know why.
Mr. Mondelli, the podium microphone is muted. We will not be able to hear you until Kathy unmutes that.
Okay, all right.
Oh, he's here.
Afternoon, Mr. Mondelli. Mr. Jenkins, Mr. Malkin, how are
Good
you?
afternoon, Your Honor.
Good afternoon, Your Honor.
Mr. Jenkins, can you mute one of your devices?
Yes, I am going to be doing that right now.
George, can you hear me?
I can.
George,
I'm here.
Can you send Ms. Robinson the special conditions of probation?
Yes, let me go ahead and I will do that. I'll scan it and send it to her.
Okay, thank you.
Make sure I have it all right. All right. Yes. That'll take me about 2 minutes, that's all.
Okay, this is 22 SC 182603.
I will do that. I apologize, Judge. Hey, Brad, can you stick in for my stead while I go scan this, Ms. Robinson?
Sure.
Well, we can wait a couple more minutes.
What was I looking at?
Y'all are both here from Ender.
Yes.
I always double check because about a fourth of the time they're in the wrong courtroom and they're getting in trouble somewhere else. So it's just merely to make sure.
One of my professors said in law school, open courtroom is the cheapest date in town.
I don't know what to think of that.
There's many ways to interpret it.
So Mr. Jenkins is scanning the conditions for you, Kathy? All right.
Can you make sure that the microphone at the defendant's table is on, Judge?
Can you say something, Mr.?
We're currently muted on the camera. But the mic is on.
Can you hear him?
Yes, it's good. Thank you.
Okay. All right. Where'd you go to law school?
Emory.
No. You've been around a while here.
November will be 19 years practice.
Oh, he's criminal defense or?
Criminal defense, I worked for the city of Atlanta for a number of years doing their federal litigation, and then I did the same work for Forsyth County and a number of places like that. Then private practice, and then my own practice.
Would you start out as a public defender or?
Yeah. Public defender here in state court. That's where I started.
Must be a lot of pages of conditions, huh?
Oh, no, Judge, I just wanted to make sure that I was able to scan it in the scanner that we have
Okay.
on my side of the building here. It doesn't work, so I had to walk on the other side. Let me make sure that we have it. So I can send it to Miss Robinson. There we go. For these to Miss Robinson. I can forward to the court as well. Let's see here.
Yeah, might as well forward it to the court.
Yeah, I will, Judge. Here we go.
Thank you.
Eatman. I was Eatman. Let's see here. Let me. Right. Just 2 seconds, Judge.
Did you get it, Kathy? All right, well, that's good
You
enough
sent
for
it?
me then.
I just sent it to you as well, Judge. Sorry about that.
Yeah, no problem, Mr. Jenkins. All right, so this is 22 SC 182-603, Quatarvius Mender, who's joining the courtroom by his attorney, Thomas Mondelli. And then we have on Zoom, Mr. Brad Malkin and Mr. George Jenkins representing the district attorney's office. Who's going to be presenting the plea?
It will be me, Judge.
All right, Mr. Jenkins, so you have a negotiated plea to present?
Yes, I do, Your Honor.
Okay, go ahead.
All right, Judge, in this case, and Mr. Mondelli, this is what we are doing. The defendant will be entering a guilty plea today, Judge, to the following, and then we can take the plea. So you'd have it, and I've emailed it to you, that he will be pleading guilty to counts 1 through 23, the entire indictment, straight up guilty plea. He will be able to avail himself of the First Offender Act, Judge. We have no objection to that. The sentence will be a 10-year sentence to serve 2 years in custody, with the balance being probated. He certainly will get time for the credit. He has been in custody on this matter since May 17th of 2022, with the balance being on probation. And so on count 1, he will do 5 to serve 2 years. On count 2, it'll be 5 years probation, consecutive to count 1. That gives us the total 10 years period. And then count 3 through 23 will be 5 years of probation, which will run concurrent with count 1. The special conditions of probation are as follows, Judge, that the defendant will write a letter of apology to the defendant. Obviously, if he's going to be sentenced today, he hasn't written the apology yet. And so we would add that to the record at some point or put that as a condition of his probation. I would say within the first 30 days or 60 days of this sentence. That we have a copy of that as well. Random drug and alcohol screens monthly. Successfully complete 400 hours of community service at the direction of the probation department or Department of Corrections. And that he must complete within the first 3 years of his sentence. Obtain his GED or high school diploma within 2 years. That is very important. He needs to have his education, complete his education for his future. If he obviously successfully completes the terms and conditions of this of his sentence, then it would help him in his future and as a productive citizen. No more threats to anyone. Certainly no contact with the listed victims in this indictment, and more specifically with Sheriff Labatt, Jackie Labatt, his wife, and Chief Appling from the Atlanta City Public Schools Police Department. He is to possess no firearms, possess no drugs unless they are prescribed by a physician for some medical related things. He is not to use social media while he is on probation. Stay away from and have no contact with any prescribed gang members whatsoever. Do not participate in any gang related activity. The case will not be early terminated. We want to put that in terms of his probation or any requests from the probation department to end probation early. We object to, and all violations or any violations that come in connection with this sentence that return to you, Judge Eaton. All right. Now, do we have a court reporter available?
Yes, sir.
All right. I guess we will start this. First of all, and I apologize here. Hold on. Can you guys even see me here?
We can see you.
All right. Judge, if you would, well, I guess I'll state it. Do you agree, Mr. Mender and Counselor, to have the judge to waive your presence and signature on the form of the indictment in this matter? I don't know, Judge, if you wanted to ask that or not of the defendant.
Wait a minute, you've signed it, right?
We've signed, I think, Mr. Jenkins, you mean to waive the presence of the prosecution. We've signed.
Okay, you signed it already? I didn't know that.
Yeah, we've signed everything.
Okay.
So we're ready to go.
The only
Okay.
signature we're missing is yours, Mr. Jenkins.
All right. Well, I give my permission, Your Honor, for you to sign on my behalf and that of Mr. Brad Malkins for purposes of this hearing and this plea agreement and sentence, Judge.
So you want me to sign both of your names?
Yes, you can sign my name on both our names. Mr. Malkin is present and worked hard on this case, as did I. So,
Okay.
No objection, Judge.
All right.
all right. Okay, Mr. Mender, as you are sitting before this court, please raise your right hand. Do you swear or affirm that the testimony you will give this honorable court will be the truth, the whole truth, and nothing but the truth to help you God or affirm?
Yes.
All right, you can lower your right hand and please state your true, correct legal name for the court reporter, spelling your first name and your last name.
Quartavius. Middle name?
State your name. What is your name?
Quartavius Mender.
And how do you spell your last name, sir?
Mender.
All right. And as you are sitting next to your attorney, how old are you?
19.
All right. And as you sit next to your attorney in this courtroom, are you under the influence of any drugs, any alcohol, any medicine that would prevent you from understanding what we are doing here today?
No. No.
And what is your highest level of education?
Ninth.
Ninth grade? All right.
Yeah.
Do you have any problems reading, writing, understanding the English language in any way such that you don't understand what's going on here today or can't communicate?
No.
All right. Are you, and I don't know if I've asked this, it's been a while, are you under the influence of any drugs, alcohol that would prevent you from understanding what we're doing here today?
No.
Any medicine?
No.
All right. And sitting next to you is your attorney, Mr. Robert Mandelli. Are you satisfied with the services at this time?
Thomas Mondelli.
Thomas, I apologize.
You're talking about the wine company there, you know?
Yeah, that's true.
Oh, well, you know, us old folks here. Mr. Mondelli, I apologize for that. Mr. Mender, did you have an opportunity to speak with your attorney on this matter?
Yes.
And did you thoroughly discuss the pros and cons of entering a guilty plea here today or the right to go to trial in this matter?
Yes.
Are you satisfied with his services at this time?
Yes.
Do you need additional time to speak with him about this plea before you enter this negotiated plea here today?
No.
All right. Mr. Mondelli, do you waive formal reading of the indictment and waive any defects as to such?
We do.
All right. Now, as I already discussed and put on the record here, but I'll say it again, you are entering a negotiated plea here today. Essentially what that means is this, Mr. Mender, you, through your attorney, and myself through Mr. Malkin, have discussed the terms and conditions of your sentence in this matter and have made a recommendation in this case. And that recommendation is as follows, that you serve a 10-year sentence to serve 2 years in custody with a balance being probated. You will avail yourself of the First Offender Act. The First Offender Act, have you discussed that option with your attorney?
Yes.
All right. And do you understand the terms and conditions of the First Offender Act?
Yes.
All right. And essentially what that means is this, is that after your sentence in this matter, and if the court accepts it and you successfully complete the terms and conditions of your sentence in this matter, you can tell future people, employers, anyone that you are not a convicted felon. This basically wipes your criminal history clean in connection with this case. Do you understand that?
Yes.
However, if you violate the terms and conditions of your sentence under the First Offender Act, the court has the right to bring you back before it and resentence you. Do you understand that?
Yes.
All right. Now, the reason why that's important is this. You are facing essentially 23 counts of terroristic threats. Do you understand that?
Yes.
And that is a felony in the state of Georgia, which carries with it a potential penalty of anywhere from 1 to 5 years as a maximum sentence here in the state of Georgia. Do you understand that?
Yes.
And so at a minimum, you're looking at potential incarceration of up to 5 years and all the way up to 115 years of incarceration if you add all the counts together. Do you understand that?
Yes.
All right. And so you could be resentenced to that if you violate the terms and conditions of your first offense sentence in this matter. Do you understand?
Yes.
All right. Knowing that, you still want to move forward with this negotiated plea here today.
Yes.
All right. All right. In addition, Judge, the special conditions and specifically the sentence, you will get time for credit for time you have served in this matter. In count 1, you will be sentenced to 5 to serve 1 year. Excuse me, I apologize. I'm losing my mind here. In count 1, you will receive a sentence of serving 5 to serve 2 years in count 1. In count 2, you will be serving 5 years of probation to run consecutive to count 1. And the remaining counts 3 through 25, you'll be on 5 years probation to run concurrent with count 1. Do you understand that, Mr. Mender?
Yes.
All right. Now, the court, you understand that even though we have a negotiated plea, the court doesn't accept this plea. Do you understand that?
Yes.
It could sentence you up to a term of incarceration or in probation in this matter at a point in its discretion it believes relevant and necessary under the statutes here in the state of Georgia. Do you understand that?
Yes.
All right. Knowing that, you still want to move forward with this guilty plea here today, sir?
Yeah.
All right. Now, by entering a guilty plea here today in this matter, you'll be waiving certain constitutional rights you have. Do you understand?
Yes.
Your Boykin rights, your right to trial by jury. Do you understand that, sir?
Yes.
In that trial, the right to have the state prove your guilt beyond a reasonable doubt. Do you understand?
Yes.
You'll also be waiving your right at trial to testify on your own behalf or your right to remain silent. Do you understand that?
Yes.
You'll be waiving your right to use the subpoena power of this honorable court to bring in witnesses and offer evidence and testimony on your behalf at trial. Do you understand?
Yes.
You'll be waiving your right to confront witnesses presented against you by the state of Georgia. Do you understand that?
Yes.
And you'll be waiving your right, if you were convicted, sir, by entering this guilty plea, to appeal your conviction to a higher court in the state of Georgia. Do you understand?
Yes.
And further, if you are not a United States citizen, Mr. Mender, by entering this guilty plea, this plea would be a violation of such and would result in your deportation from this country as a conviction. Do you understand?
Yes.
All right. Further, if you want to challenge the voluntariness of this plea, you have 4 years from today's date to file what we know as a habeas corpus motion petition. Do you understand?
Yes.
And also, if you are currently on probation or parole here in the state of Georgia or any state in this country, do you understand by entering this guilty plea, would be a violation of the terms and conditions of any probation or parole you may happen to be on. Do you understand that?
Yes.
All right. Now, the charging instrument, I don't know where it is, but prior to this date, did you speak with your lawyer and go over that charging instrument in this indictment 22 SC 182603?
Understand the question.
No.
Mr. Jenkins, just 1 second. The charging instrument is the document called the indictment. It is the document that lays out the 23 counts of terroristic threats that you entered the plea on, this that we looked at again today as well. Knowing that as further description, you understand Mr. Jenkins' question now?
Yeah.
So to be clear, just to step into Mr. Jenkins, that I have that document, it's the indictment. And you recall signing under the guilty check mark, correct?
Yeah.
Where it says first offender beside it. You recall all that? Okay.
All right. And when I must say that in addition to, and before, I know I wasn't as expressive in the plea, although I have stated it already on the record. Let me make sure that it's present so you understand before you enter a plea of guilt in terms of the conditions of probation. While you're on probation, the special conditions are and will apply to you, Mr. Mender, that you certainly don't threaten anyone, that you possess no firearms, that you possess no drugs other than prescribed by a physician, that you submit yourself to random drug and alcohol screens monthly. During the time of your probation, you are not to use social media. You are to stay away and have no contact with any known gang members. You are not to participate in any gang-related activity. You are obtain your high school diploma or GED equivalent within 2 years of being placed on probation after you've turned your time in custody. 400 hours of community service at the direction of the probation officer in this place, and you must complete that within 3 years of this sentence. Usual general conditions on the sentence sheet will still apply to you, Mr. Mender. The case will not be available, and we will object the state to any early termination recommendations in this case. All violations of this sentence will return to Judge Eaton. Also, you must write a letter of apology to all victims in this indictment, and specifically within the first 30 or to 60 days of the sentence to Sheriff Patrick Labatt, to his wife, Jackie Labatt, and to Chief Ronald Applin of the City of Atlanta Public Schools Police Chief in this matter, and any other terms and conditions the court deems appropriate in this matter. Do you understand?
Yes.
All right. Now, the judge was telling you in terms of the charging instrument, which is the indictment in this matter, and you signed your name on that indictment. But prior to signing your name, did you discuss the charges, the pros and cons, your defenses with your attorney in this matter?
Yes.
And did you understand in your communications with your attorney while discussing it with him?
Yes.
And as a result of that discussions, you decided to enter a guilty plea here today. Is that correct?
Yes.
And did you do that freely, voluntarily, and knowingly when you signed your name on the instrument?
Yes.
That means this indictment. All right. After seeing such, and Mr. Mondelli, did you sign your name on this indictment as well?
I did.
And what is the date of the indictment that it's been signed, that you signed it, Mr. Mender? Dated as what date?
August 17th,
And what year are we in?
2023.
All right. All right. And did you do the same, Mr. Mondelli?
I did.
All right. In indictment number, I think the plea has been entered. At this time, I will ask you in 22 SC 182603, charging you in counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 23, all carrying with the offense of terroristic threats, At this time, sir, how do you plead?
Guilty.
Your Honor, the charging instrument has been signed. The plea has been entered before you here today. And briefly, the factual basis for this plea is as follows, Judge. Hold on. Essentially, on the 14th of May, 2022, the sheriff, Labatt, reached out to, and members of the Fulton County Sheriff's Department reached out to the Atlanta Police Department in connection with threats that were being levied against them on Instagram, essentially making threats against Mr. Labatt himself, the sheriff, his wife, Jackie Labatt, in that matter. There were additional threats to several other agencies. The defendant actually made threats through other sites, law enforcement sites here in the Atlanta metro area, pointed at both the sheriff and his wife. In addition to the threats being made, he made threats against the APS police chief, Ronald Applin. But what happened was, in this case, was this. And on that date, essentially, social media threats, they were saying that free Young Thug, or you will be assassinated and your wife will be assassinated. Essentially, initially, the Instagram account making these threats were from YSL Fat J. And to give some context in this matter, approximately a week or 10 days prior to this incident, a large RICO gang indictment was returned in Fulton County Superior Court judge. And on that indictment is the cousin of the current defendant here today, and is still under indictment in that matter, which gives the context and potentially motive for engaging in this conduct and issuing these threats against the sheriff, his wife, and others, and specifically Mr. Ronald Applin. At which time, certainly, the police began their investigation. Atlanta Police Department, along with federal authorities and the Fulton County District Attorney's office, engaged in their investigation. They found that the initial Instagram post or handle, if you want to call it that, was issuing these threats was actually, they initially thought was a Jamerson McCarney, but further research and analysis discovered that that was not the case, and that was a fake name. Basically, he was putting out these under that handle as a Fat J, but it wasn't really him, even though that Fat J was an actual person. It was the investigators, once they subpoenaed the records for Instagram, and they found that the phone being used in this case was a phone that was issued to the defendant's mother, Danica Kelly. At which time, based on their investigation and search warrants, they were finding that the phone and using certain techniques from the federal authorities with the FBI and the Secret Service found that that phone was actually in service and actually pinging off of a cell tower near the location which the defendant was arrested, which was on Sells Avenue, essentially around the corner from Morehouse College. Specifically, the address is 960 Sells Avenue, City of Atlanta, 30314. At which time they were able to get a search warrant for the phone, a search warrant for that location, and executed a warrant on the 17th day of May 2022. And when police entered the home, the defendant actually was detained after walking out of the back of the townhome that's there right near Morehouse's campus in the city of Atlanta, and also in Fulton County. That the phone he had, the phone that was used to issue these threats was essentially in his hand when he was detained. After he was detained, the phone was taken and analyzed at the Secret Service, corroborating the origin of the threats. And the during the time that he was detained, the defendant's mother corroborated the fact that it was a new phone and that while the phone was registered to her, she had given it to him a month prior to this defendant, a month prior to the issuance of these threats, because the defendant had broken his other phone. This is the same phone that he had in his hand at the time he was detained by the Atlanta Police Department. While the phone was being analyzed, this defendant was taken to headquarters by the Atlanta Police Department and interviewed by Investigator Sluss from the Atlanta Police Department and an investigator from the Fulton County District Attorney's Department. And during the course of this investigation, after being Mirandized, this defendant did admit issuing these threats to the victims listed in the indictment in this case, specifically, and more specifically, Sheriff Pat Labatt, his wife Jackie Labatt, and Ronald Applin. However, there are other threats. As a matter of fact, the defendant sent out social media threats in the amount about to 31 different people, entities, and agencies during this period of time. So, which was unfortunate, certainly, in this case, Judge. And we certainly acknowledge the age of this defendant. This plea agreement has been proved based on the discussion with Madam DA Fonnie Willis, her understanding the serious nature of, as we all do, the serious nature of this conduct of this defendant. But we certainly put in the temper that with the age and youth of this young man and his willingness to take responsibility for his conduct, which all parties appreciate in this matter, in this case. And so with the phone being in his hand, that phone being the actual phone issuing the threats, and his admission is the basis for him entering a guilty plea to all 23 counts of this indictment, Judge. That's the factual basis for this plea. I will leave it in your hand to speak further. And any other terms and conditions or any adjustments to this plea, the state would welcome in this matter, Judge. Thank you.
Mr. Jenkins, have you discussed this plea with the victims?
Yes, Judge, we have left messages with Mr. Labatt and Mr. Applin in this matter at this time. And so we have not heard otherwise. They object to this plea agreement in this case. And so we are ready to move forward, Judge.
What's the maximum sentence for terroristic threats again?
Well, per charge,
Felony.
it's 5 years, Your Honor.
5 years.
Judge, I made a scrivener's error on the plea paperwork. And it's 10 is 5, so it should be a maximum.
Mr. Mondelli, could you please speak into the microphone?
There you go. Can you hear me now?
Yes.
Judge, I made a scrivener's error on the plea paperwork. The maximum sentence should be 115 years potentially.
Oh yeah, I see where you wrote 230.
I was thinking terroristic acts, which is a 10.
Yes, that's 1 to 10.
Okay. What do you want to, you want to change that and initial it?
I'm making my correcting it on the record here with the court reporter. You can strike through it, Judge, and write 115 if you wish.
Okay, I'll do that. What does it need to be?
115.
115. All right, Mr. Mandelli, it's your turn.
Judge, this is obviously a troubling case for a number of reasons, but we join in appreciating the district attorney's office willingness to work towards a negotiated resolution here rather than force the matter into a trial posture. We do ask you accept the plea as negotiated under the First Offenders Act. My client, as has been stated, is 19 years old and has only a 9th grade education. As you can see on the plea paperwork, my client has received previous mental health treatment as a juvenile. And I would submit, Your Honor, that the totality of his life experience, including the need for that treatment, was part of what brought this matter about. My client, ironically, is not even necessarily close with his cousin, who is a defendant in the RICO case that the state referenced. Yet that was a part of the impetus here that brought this case to brought this case forward. This is an example of something that I see constantly throughout my practice where the desire to appear tough or cool or, somehow, somehow connected has led a young man into a dangerous predicament that, had things gone just slightly differently, could have been incredibly dangerous for him. So, Your Honor, we recognize that, fortunately, at this point in time, my client understands the gravity of the situation. My client understands that this is something that should never have happened. He regrets it. He has been remorseful to me in my meetings with him about what happened. And this is something that will never, ever repeat itself. So, Your Honor, we recognize that the state has given him a chance to move forward with his life. He has served approximately, I think, 15 months at this point of the 2 years, and we'd ask that he receive credit for that. He knows he has a long road ahead of him in terms of community service and those matters, and we had asked for the opportunity for him to make good on his commitment to the court and to the district attorney's office and the community to allow him to enter this plea, Judge. I will note two things. First of all, as I stated before proceedings began, my client's parents, his mother and father, are both in the courtroom in support of him. I will note that my client has never been a gang member. He is not verified as a member of YSL or any other street gang organization. This is, again, an instance of a person copycatting, being a wannabe, for lack of a better term, something we see far too often, especially on social media. The other thing I will disclose to the court is, prior to this incident and arrest, and the state knows this as well, my client had previously been arrested in DeKalb County for an instance of aggravated assault. That case remains unindicted in DeKalb County at this time. It is a self-defense case. When the time comes, I am his counsel of record on the pre-indictment file. I will be his counsel of record if and when the case gets indicted. I'm bringing this to the court's attention, not to muddy the waters, but to point out that in my estimation and my client's relative near future, he will be having to deal with another criminal matter for which he will not be first offender eligible anymore. One that I anticipate we will have to actually bring forth to trial because it's a self-defense case. And given that it predates this case, I would submit that it should not be a basis for a revocation of his first offender status or his probation should things not go his way. But otherwise, Judge, we ask the court to accept this plea. We understand its terms and conditions, and ask to be able to move forward.
I'll make sure. I'm going to ask a few questions on first offender with your client before I get into the plea, because I really want to make sure he understands what he's getting into with this, because there's some pros and some cons for sure. There's some very tight conditions on here, and I as you've alluded to, the community service, but some seemingly innocuous conditions on here that sometimes I wonder teenagers might have the most difficult time dealing with. And, specifically, I'm looking at the no use of social media. So he'll be out on 8 years of probation. And if he gets on any social media, he could be back in here with a revoked first offender facing 115 years for terroristic threats. I mean, have you been abundantly clear to your client about that?
Yes, Judge.
Because some of what first offender, I'm sure, is designed for is, you have that brief second in time that well, I guess in this case, it wasn't a second, it was many, many terroristic threats, but that brief moment in time that you look back on, and hopefully your client does, and realize just how ridiculous and stupid that was. And it gives you the opportunity, in this case, it'll be 8 years of probation once he's released, if he complies with all these terms, to not have a record. But I see his parents sitting out there. I appreciate them being here. I mean, so how old was he when he did this? 17?
18.
18? I mean, he's 19 now. I mean, he's I mean, from a legal standpoint, he's a man. But, you know, I would call on his parents to help him as well, to make sure that they keep a watchful eye on him. Because this is a once in a lifetime opportunity here, this first offender. I mean, I think, as you've seen, I mean, my Lord, the FBI, the Secret Service got involved in this. And it's not anything I take lightly, that's for sure. I mean, I think anyone who, you know, attempts to intimidate those who serve our justice system, in essence, try to change outcomes. I mean, that's something that was obviously taken very seriously, as shown by the level of district attorneys that are involved here, the FBI, the Secret Service getting involved, and then, of course, you know, threatening the spouses and wives of these officials takes it to an even higher level in my mind, and it's completely unacceptable. But we do, as I get back to the first offender, we do get back to this once in a lifetime opportunity. I just hope that, like I said, there's a lot of conditions on here, and you know, Mr. Mender, I mean, it was 2 years ago, but you didn't really think through the ramifications at the time that you were making these threatening messages to our sheriff and his wife and the police chief. You didn't really think that through. You didn't really think through what the ramifications would be. And I want to make sure that you completely understand what the ramifications will be this time if you attempt to pull out Instagram or any sort of social media and create a profile and go on there. And I know you already said you did, Mr. Mondelli, but Mr. Mender is going to be one of very few 19-year-olds in the world who won't be using social media. You understand that, Mr. Mender?
Yes.
Your parents understand that? So if you, as a first offender probationer, violate the terms of your probation, the court may enter an adjudication of guilt and proceed to sentence you to the maximum sentence provided by law. And I've gone over that with you. I want you to understand that if an adjudication of guilt is entered, you may be sentenced to a greater or more restrictive than that opposed today. That's the two-edged sword of it. But however, if you are so sentenced, you'll receive credit for the time served on probation of any new sentence. On a positive note, I really want to believe in the positive. I want to believe in this second chance. If you successfully complete this sentence, you will have not been convicted of a crime. And, you know, that's going to be important when you apply for jobs and they do background checks. So have you ever been convicted of a felony, Mr. Mender? I'll ask one more time.
No.
Okay, you fully understand the conditions of this first offender sentence.
Yes.
And you understand this is a once in a lifetime opportunity.
Yes.
Do you still want to receive your first offender sentence?
Yes.
Okay, Mr. Mender, do you understand the nature of the charges against you?
Yes.
You have just heard from ADA Jenkins explain all the rights you give up by this guilty plea. Is it your wish to give up these rights
Yes.
and have this court accept your plea of guilty?
Yes.
Do you understand this court is not bound by the recommendation or the plea agreement, and I can sentence you as I deem appropriate?
Yes.
Are you pleading guilty because you are in fact guilty?
Yes.
Mr. Mondelli, are you satisfied that your client is competent in understanding that the plea is voluntary and that there's sufficient factual basis for entering the plea?
I am, Judge.
Okay, the court finds that you, Mr. Mender, understand the nature of the crimes, the consequences of this plea, there is a factual basis for the plea and the defendant has knowingly, intelligently, and voluntarily entered the plea. Defendant has requested a sentence under the First Offender Act. Court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the negotiated sentence. So overall, it will be a 10 to serve 2 with credit for time served, 8 years probation, and that how that is done is on the first count, it'd be 5 to serve 2. Second count will be 5 probation. And then the rest of the counts going all the way up to 23 will be 5 years probation concurrent to count 1. Well, it'd be, is that, they're concurrent to count 1, correct, Mr. Jenkins?
That is correct, Your Honor.
Count 1. So count 2 stands out by itself. That's 5 years probation to be consecutive, which makes it the 10 to serve 2. Special conditions, written letter of apology to be read into the record. Well, we've already discussed that because this is sentencing. So he is to provide a written letter of apology that will be included in the record. When can he have that written letter of apology?
Judge, I believe the state asked for, I think, 30 to 60 days. I would suggest the following, that Mr. Mender mails his letter, since he may be transported to DOC custody, mail his letter to his mother. His mother can provide it to me, and I will provide it to Mr. Jenkins, Mr. Malcolm, and to the court.
And this letter must be to Jackie Labatt, Sheriff Labatt, and Ronald Applin. So that's 3 different letters.
3 different letters.
And that is Jackie, Jackie.
So we that's our understanding.
And Chief Applin.
Chief Ronald Appling of the Atlanta Public Schools Police Department.
Okay, so 3 separate letters. Can what you're talking about, writing a letter, possibly from the DOC, sending it to his mother, and his mother distributing it to us in the courthouse, can that all happen in 60 days?
I believe it, man, I believe it can, Judge.
Okay.
Usually, I think the letters could be started on today, and,
Yes.
Frank, and I can even provide my client with additional paper right now, take it with him. And then
The quicker the better, because I mean, the victims are entitled to this apology. All right, well, we'll just, so there's a date certain, we'll make it 60 days, but it ought to be done a lot quicker than that. Random drug and alcohol screens monthly. Upon release from confinement, successfully complete 400 hours of community service at the direction of your probation officer, and that must be completed within 3 years of release. Obtain a high school diploma or GED within 2 years. Can he get started on that while he's incarcerated?
Yeah, I'm assuming he can.
it's a tough question, Judge, given how much time he has left. The Department of Corrections is going to make a determination as to his classification, where he's going to go. Depending on that, there may be an ability to enroll him in GED, but I can't say for certain, given that we're talking about on the outside 9 months before he maxes out on the incarceration time. I'm not sure if DOC can accommodate that fully. He can certainly try to get started, but regardless, he understands that while understood it says GED has to happen, and I believe the state's recommendation required within 2 years, Mr. Jenkins?
Well, he has 2 years. I didn't know whether it's 2 years from today or 2 years upon release.
No, he gets credit for time served. And so, you know, it
Well,
doesn't matter when he
what
starts.
I meant is
Okay.
obtain the GED or diploma within 2 years of today. Or
Yes.
does he have until his release to begin working on his high school?
I think it would be appropriate, and because it's so vital for him as a young youth, that it be within 2 years of today.
Okay.
I don't care how he does it.
All right, 2 years of today. You are not to threaten anyone, possess no firearms, possess no drugs unless prescribed by a physician. You are not to use any social media. You are to stay away from and have no contact with any known gang members. You are not to participate in any gang activity. And your case will not be terminated, will not be early terminated. And any violations of your probation will return to me. Is there anything else?
Yes, I apologize, Judge. If we didn't put it on the record, he is to have absolutely no contact or any contact through any third parties, anyone in connection with Sheriff Patrick Labatt, his wife Jackie Labatt, and Chief Ronald Appling.
Okay. He is to have no contact or any indirect contact through third parties or other sources with Sheriff Labatt, his wife Jackie Labatt, or Chief Appling. Anything else?
Not that I can think of at this time. Mr. Malcolm, do you have anything else that I've missed?
Oh, I think that you've covered everything very well. Thank you.
All right, Mr. Mondelli, anything from you? All right, Mr. Mender, I've done my best to convey to you the gravity of this situation and also the difficult road that you have ahead of you. I mean, there can't be any slip ups again. What you did was extremely serious. And I know your parents understand that as well. There were a lot of people that got involved in it, and we all take these sort of threats very, very seriously. And I just want to convey to you how serious this is, what you have ahead of you for the next, I don't know, how many months is it? So he's done 400, according to my notes, 449 in jail. Well, we'll call it what the time he has remaining in jail. I mean, in prison, possibly a DOC, and 8 years of probation. You've got a long road ahead of you. You're going to need to stay out of trouble. But if you accomplish all of that, you'll have a clean record and you can move on with your life and hopefully become a productive citizen. Understand that, Mr. Mender?
Yes.
Okay. All right. You're excused.
Thanks, Judge. Judge, after I speak to my client in the back, may I be excused?
Pardon me?
After I speak with my client.
You're excused.
Thank you.
And
Thank you, gentlemen.
all right. We're adjourned.
Thank you, Judge.
Thank you, Your Honor.
Thank you, gentlemen.
Thank you, Mr. Mondelli. Ms. Robinson.
Thank you. I'll see you outside in a minute.
Brad, give me a call in about 2 minutes, would you?
Yeah, sure.
Thanks.
Okay, see you.